Good morning and welcome you all for the seminar on feasibility of Uniform Civil Code in India. The conference aspires to explore the role of the Uniform Civil Code in newer dimensions and in the light of the issues currently faced by the society. audience, the program will begin with a couple of minutes. We have two events. We begin with the formal program and we will have technical session at the second part of the program. Please maintain the decorum. A very good morning to you. Vivekananda Law College, in association with PTA, Alumni Association and Rotary Club Puttur, welcome all of you for the National Seminar on Indian Uniform Civil Code 2023. Good morning to all of you. I request Srimati Akshita AP, the principal of our college, to escort the dignitaries onto the stage by offering flowers to Bharat Mata. It's a great privilege to have the presence of Dr. K.C. Sunny, Professor, Central University, Kerala, Sri M. Ramohan Rao, Senior Advocate, Puttur, Dr. Aruna Shyam M., a proud alumnus and senior advocate, Dr. Prabhakar Bhatt Kaladka, the president of Vivekananda Vidyavardhaka Sangha, Sri Surendra Kiniji, president, and Sri Vijay Narayana KM, the correspondent of College Governing Council, and Dr. B.K. Ravindra, Director of Legal Studies, Vivekananda Law College, Puttur. May I request Srimati Akshita AP, the principal of a college, to escort the dignitaries onto the stage by offering flowers to Bharat Mata. We have gathered here for the seminar on feasibility of uniform civil code in India. May I request the dignitaries to have their respective seats. Let us begin the auspicious day with a prayer. I call Ms. Gayatri, our 4th BLLB, upon stage and invoke the Lord Ganesha.
गणनाथ स्मरिसुवे देवा चिरमतिय पालिसु जिया गणनाथ स्मरिसुवे देवा चिरमतिय पालिसु जिया आदिपूजित लोकवन्दित आदिपूजित लोकवन्दित गौरी शिवसुत श्री गणनाथ गौरी शिवसुत श्री गणनाथ गणनाथ स्मरिसुवे देवा चिरमतिय पालिसु जिया अनुदिन नारायणನೆಂಬ ನಾಮವ अनुदिन ನಾರಾಯಣನೆಂಬ ನಾಮವ ಪಾಡುತ್ತಲಿರುವಂತೆ ಮಾಡು ನಿಮನವ ಪಾಡುತ್ತಲಿರುವಂತೆ ಮಾಡು ನಿಮನವ ಗಣನಾಥ ಸ್ಮರಿಸುವೆ ದೇವಾ ಚಿರಮತಿಯ ಪಾಲಿಸು ಜಿಯ गणनाथ स्मरिसुवे देवा चिरमतिय पालिसु जिया चिरमतिय पालिसु जिया चिरमतिय पालिसु जिया
Thank you, Gayatri. May I ask Srimati Akshita AP, the principal of our college, to welcome the gathering.
Good morning to all. Uniform Civil Code means unifying all the personal laws to have one set of secular laws dealing with the aspects that will apply to all citizens of India irrespective of community they belong. In a layman's language, it means one country, one rule. Basically, Uniform Civil Code is a try to give the whole picture a regulated and systematic look. Recently, the Law Commission of India issued notification asking general public to give their opinion about the Uniform Civil Code. In this appeal to the public about the implementation of Article 44 of the Indian Constitution, Vivekananda Law College has taken the lead to elicit the opinion both for and against from all the sections of the society. Welcome you all for this national seminar on Indian Uniform Civil Code. It's an immense pleasure to welcome the gathering. I extend my warm welcome to the inaugurator of this program, former Vice Chancellor of National University of Advanced Legal Studies, Kochi, Dr. K.C. Sunny, Professor and Dean of Central University Kerala. A warm welcome to you, sir. I request Shri Sudhir Kumar Tolpadi, advocate and a senior faculty of our college, to welcome the guest with a book. I extend my warm welcome to Dr. Parladka, the president of Vivekananda Vidyavardhaka Sangha, a guiding spirit in all our endeavors. A warm welcome to you, sir. I request Srimati Geeta Gauri Madam, faculty of our college, to welcome the president with a book. It's our privilege to have Sri M. Rammohan Rao, Senior Advocate Puttur, as a chief guest for this national seminar. In spite of his busy schedule, he consented to be with us and agreed to be the part of technical session to speak about the topic Uniform Civil Code. He has been a supporting pillar to our institution since its inception. Being in advisory committee, he has actively guiding the institution to reach new heights. A warm welcome to you, sir. I request Srimati Annapurna V. Shetty, Senior Faculty of our college, to welcome him with a book. It's my pleasure to welcome Dr. Arun Sham, our proud alumnus and senior advocate, former Additional Advocate General of Karnataka State, a member of Academic Council, National Law School, India University, Bangalore. A warm welcome to you, sir. On behalf of Vivekananda Law College, I take this opportunity to congratulate you on receiving PhD award from Alliance Law University, Bangalore for the successful completion of research study. Congratulations to you, sir. I request Dr. Rekha K., Assistant Professor of Law of our college, to welcome him with the book. I take this opportunity to welcome President of our College Governing Council, Sri Surendra Kini, who is a businessman by profession and an active social worker by profession. I extend a warm welcome to you, sir. I welcome Sri Vijayanarayana KM, our alumnus, advocate, as well as correspondent of our college. Welcome you, sir. Dr. B.K. Ravindra, Director of Legal Studies, is a man behind this initiative to organize this seminar on Uniform Civil Code. He has been mentoring and guiding us and is our backbone. I extend my warm welcome to Dr. B.K. Ravindra, sir, Director of Legal Studies. Welcome you, sir. Our College Governing Council as a team has been supporting and encouraging us in all our programs and activities and helping us to unleash our potentials. I welcome all other Governing Council members who are present here today. A warm welcome to you all. I also extend my warm welcome to the resource persons of today's program, Dr. Sairam Bhatt, Professor of Law, National Law School of India University, Bangalore, Dr. K.R. Aital, Professor of Law, Presidency University, former Dean, Faculty of Law, Karnataka University, Darbe. I welcome the directors, members of VVS and Governing Council members of sister institutions. And it's my pleasure to welcome President, Secretary and members of Alumni Association and advocates from different bar association for their August gathering. I welcome President and Secretary of PTA and all the parents and participants from different departments, association and also general public who are present here today. And I welcome media people for their wide coverage and all the staff members and the energetic student community of all institutions for their cooperation and dignity. I welcome you all. Once again, I welcome all of you for this program. Thank you.
Thank you, Madam Akshita. A heartwarming welcome to you too. May I request the dignitaries on the stage to proceed to the lamp to inaugurate the ceremony by lighting it.
दीप ज्योति परंज्योति दीप ज्योति जनार्दनः दीपो हरतु मे पापं दीप ज्योति नमोस्तुते शुभं करोतु कल्याणं आरोग्यं सुख संपदः द्वेष बुद्धि विनाशाय आत्मज्योतिर्नमोऽस्तु ते आत्मज्योतिप्रदीप्ताय ब्रह्मज्योतिर्नमोऽस्तु ते ब्रह्मज्योतिप्रदीप्ताय गुरुर्ज्योतिर्नमोऽस्तु ते गुरुर्ज्योतिर्नमोऽस्तु ते गुरुर्ज्योतिर्नमोऽस्तु ते.
Thank you. May I request the inaugurator of the program, Dr. K.C. Sunny, Professor and Dean, Central University, Kerala, to deliver a speech. Over to you, sir.
Respected President of this session, Dr. Prabhakar Patke, President of this institution and the society managing this institution, Sri M. Ramanohar Rao, Senior Advocate, High Court of Bangalore, High Court of Karnataka, Dr. Aruna Sham M., Senior Advocate, Sri Surendra Kini G., President, Governing Council, Dr. B.K. Ravindra, Director of Legal Studies of this institute, Ms. Gayatri, Srimadi Ashalada AP, Principal, Srimadi Lashmikant A., Senior most law professor and eminent scholar, Professor Dr. K.R. Aityal, my friend and promising academic, Professor of National Law University of India, and Director of Center for Environmental Studies, Professor Dr. Sai Ram Bhatt, other law teachers present here, dear researchers and students. I am extremely happy to be the part of this event. This is my second visit to this institution. First visit was immediately after Dr. Ravindra assumed the charge of Director of Legal Studies. I got one invitation 2 years back, but because of some circumstances beyond my control, I didn't turn up for the event. It is nice to see that after Dr. B.K. Ravindra assumed the charge of Director of Legal Studies of this institution, there is lot of improvement in terms of improvement of physical infrastructure and digital infrastructure, and improvement of the academic activities of the institution. I hope that this trend will be continued and this institution will get NAC A++ within few years. Best wishes for all the members of the Governing Council and academic staff. Today we are going to discuss an issue having very serious consequences as far as Indian society, Indian politics, and individual rights of individuals living in India are concerned. Since another technical session is scheduled and eminent scholars like Professor Aital and Sai Ram Bhatt are going to present there, and my presentation is also scheduled in that session, I am not going to the details of the theme of the seminar. Anyway, implementation of Uniform Civil Code is an action. Before taking an action, we may pose certain basic question. Why this action? What is the action? How this action may be taken? And when this action may be taken? The issue is implementation of Uniform Civil Code. That mandate is contained in the Constitution itself in Part 4 of the Constitution. But we have passed nearly 17 years after independence. So, the present generation is entirely different generation. I was in teaching profession for last 38 years. And being the teacher, my criteria to determine a generation is 5 years. I think Dr. Sahira Bhatt also will agree and Professor Ravindra will also agree. If one batch of 5-year course students completed, the new batch may be a different generation. In terms of value orientation, in terms of style of life, in terms of pattern of behavior, in terms of appearance and apparels. So, as far as society in general is concerned, we may enhance that period to 20 years. So, this may be, this generation, the present generation or present generation below 20 years may be treated as fourth generation after Constitution. Fourth generation after enactment of the Constitution. So, when we are discussing about the implementation of Uniform Civil Code, the changes happened in the society during these 70 years may also be taken into consideration. And Uniform Civil Code may be something taken from Hindu law, something taken from Islamic law, something taken from Christian law or Sikh law. The modern ideas may also be taken into consideration. Modern concept may also be taken into consideration. Here, one decision by the Madras High Court is very relevant in relation to matrimonial property. The property acquired by a person after the marriage may be the joint property of both husband and wife. Wife may be housewife. Husband may be employed. All property acquired after marriage may be the property of both. Husband may not be a person having any job in civil service or something like that. Wife may be a civil servant. The property acquired after marriage may be the property of both husband and wife. Such new ideas may be incorporated in the Uniform Civil Code. Only these words I am concluding. I express my sincere thanks to the management, director and principal for inviting me to the seminar. I declare this seminar being inaugurated. Thank you very much.
Thank you, sir. Through your inaugural address, you have triggered many questions in the minds of audience regarding implementation of Uniform Civil Code as an action. Surely these questions would be answered in the technical session afterwards. May I request the Chief Guest of today's program, Shri M. Ramohan Rao, Senior Advocate of Puttur, to address the gathering. Sir.
Respected persons occupying the various seats on the dais, without naming individual because I am given only 4 minutes time, and the younger generation studying law, perhaps they will be more effective and affected by the law to be implemented. Perhaps the group consists of various sects including religion. The point for you to consider actually, from my point of view is, today the age limit for casting vote has been reduced even to the new generation. And therefore, in course of time, the bulk of the parliamentarians perhaps to be elected will be reflecting the ideas of this new generation. So the prime idea of implementing Uniform Civil Code is how they want it to be in future for their course of action in the life and society concerning the laws covered by 7th schedule. Now there are some problems even implementing the law. As you know, the Pondicherry was a French electorate with the representatives sent to Paris to guide their law. Goa had Portuguese law. Tribals had their own customs and rights. And India became a nation. There was an assurance that their law will not be affected. So also promises were made to the kings who acceded to join Indian Union. That promise also was either kept or not kept, we don't know, I don't bother. But so far as criminal law is concerned, you will find the Britishers were wise in ruling us. They introduced Criminal Procedure Code. So far as the implementation of civil law is concerned, they implemented throughout India the Civil Procedure Code. These are procedural law, but law governing individuals is not yet implemented, which will be applicable to all citizens of society. I will deal with the subject later, so far as applications of different types of law. But I find the subject covered by Schedule 7 of the Indian Constitution touches marriage, divorce, property rights, will, adoption, etc., etc. Each law provides peculiarities, but there should be uniformity in all these laws so that a common man will understand what the law by which he should follow the point. So with these aspects, perhaps 4 minutes time, digression on the subject will be dealt with later because the subject is just like a hot coal. It is just like condensing the whole globe into a tennis ball and imparting you to the idea how it should be. That, of course, our friends also will join on implementation of the Uniform Civil Code, how it should be, but it is your idea that is more important. We should touch the commission intended for formulating the law. After all, this law will not be passed unanimously or immediately, we don't know. It will be introduced in the parliament. The lawmakers will be the persons are to be elected by you. And they may be politicians, they may be educationists or anybody. The choice is yours. Your voice, therefore, will be heard more in the parliament than people who have crossed that age. But even people who are old also require a law. Their protection is more important. So also the younger generation even less than the voting rights. Therefore, all the subjects are covered by schedule of the Indian Constitution of which we are concerned. I will elaborate on some problems which we have even within India, why there should be uniform civil code. Later, when opportunity is given to me to perhaps project my ideas on the point. Of course, it is for you to introduce the questions to the people here who will answer all the points. Perhaps there are luminaries on the subject here, perhaps more better equipped than me on the subject, because I face more problems rather than answers, because we are in the official stage itself. We don't argue a case on the constitutional basis in subordinate courts. So, let me therefore, in the initial stage, thank you for permitting me to address you at this stage within the short span of 4 minutes. I thank the association as well as all of you to be alert in answering, asking questions, so that our brains will become more sharper. Thank you.
Thank you for addressing this younger generation studying law. Sir, they belong to the generation Alpha. And this topic surely needs a lot of discussion. Thank you for making our audience thoughtful. And sir would be addressing us again in the technical session on the topic Uniform Civil Code. Now I would request Sri Aruna Shyam, a proud alumnus and senior advocate, former Additional Advocate General of Karnataka State, to address the gathering. So over to you.
Honorable Shri Dr. Kalladka Prabhakar Bhattji, President of Vivekananda Vidyavartak Sangha, Professor Dr. K.C. Sunny, Professor Sai Ram Bhatt, Professor Aital, and Professor Dr. Ravindra, Principal of the College Akshata, our friend Vijay Narayana, correspondent, Shri Surendra Kini, and all faculty members of Vivekananda Law College, my dear friends, this is the first of its kind, I believe, in Karnataka. A college is coming out with a national seminar on this burning issue. I should congratulate this institution for having this wonderful burning issue as a topic for national seminar. These kind of seminars are more required because lawyers are social engineers. We are all social engineers gathered here to discuss about a burning topic. We are the most responsible citizens, I would say, because we know law, we know society, we can suggest the changes whatever required in the field of law by pointing out the practical difficulties and the need of the hour. This Uniform Civil Code is a concept which was existed from long time, but it has been implemented to a certain extent so far as criminal laws are concerned, as my senior friend already told. These laws are codified during the British regime, and we are in a way beneficiaries, and in a way this is a tragedy created by dividing the law in the name of religion. That is why we are suffering this, and we are having this topic today. Otherwise, if then it was codified, it would not have been a problem, and people would have accustomed to this uniformity. Unfortunately, it was not done, and the British rule divided the law on the basis of religion, and now we are here to separate it at this late hour. During the independence, this has happened. Then after independence, while framing the constitution, this was one of the aspects for consideration before the Constituent Assembly Committee, for this drafting committee, what we call, headed by Dr. Babasaheb Ambedkar. The question was whether this Uniform Civil Code was supposed to be in the list of fundamental right, or what has to be done. Then after thorough discussion or a marathon discussion among the Constituent Assembly Committee, it was suggested that this Uniform Civil Code concept should be shifted to Directive Principles of State Policy, and later it has become Article 44, as you all are aware. But the discussion was before the Constituent Assembly Drafting Committee and also the Constituent Assembly, why it should be in the why it should be in the directive principles of state policy. There was a discussion, and ultimately Dr. Baba Saheb Ambedkar also of the opinion that that was not the appropriate time to make it a fundamental right or impose this uniform civil code. People were not ready, and their mindset, education, social background, all these things were not proper time for this kind of uniform civil code. So after discussion, it was shifted to directive principles of state policy, and thereafter all law commissions had discussion about this, and even in 70s there was a proposal for uniform civil code. At that time, some of the organizations of some religion protested, and government didn't choose to implement it. But simultaneously, central government more particularly, implemented certain laws in this direction. For example, Child Marriage Restraint Act, Dowry Prohibition Act, all these acts in a way points out uniform civil code only. Basically, uniform civil code is a concept, or it is a theory that oneness, one nation, one law, and for that reason only all these laws should be one. Now there are many laws which points out uniformity. For example, Indian Penal Code, then Transfer of Property Act, everybody has accepted it. Now all these laws are accepted, but why can't uniform civil code so far as marriage, divorce, inheritance, succession, or any of such kind of things? But people have a doubt, or people are creating doubt whether this uniform civil code concept interferes the religious beliefs of any religion, or whether it violates fundamental rights of religion or citizens of India, is the question that is cropping up. I must tell you this, that none of this concept of uniform civil code would violate fundamental rights, because the essential religious practice is not being touched by this uniform civil code. Only which is day-to-day life or day-to-day affairs of the people, which is considered as secular activities of the people, are regulated by this kind of uniform civil code. Nothing like practice of religion or their tradition. No, nobody is interfering with that. There is no such proposal at all. So ultimate object is one nation, one law, and we are assembled here to discuss about it. I think you all have many more questions about this, and our technical sessions will address all those questions. And I will also try to be here for some time and participate in this very uniform and very unique concept called Uniform Civil Code. Thanks for the opportunity to address all of you. Thank you one and all.
Thank you, sir. Our law students, budding advocates there, they need guidance and advice from legal luminaries like you. Dr. Ansham, thank you so much for addressing our students. We recognize the presence of Shri Bharat Bhai, member of VVS Management. I extend a warm welcome to you. May I request Dr. Prabhakar Bhatkaladkar, the President of Vivekananda Vidyavadhyaka Sangha, to deliver presidential address. Over to you, sir.
ಎಲ್ಲರಿಗೂ ಜೈ ಶ್ರೀರಾಮ್. ಸ್ವಲ್ಪ ಗಟ್ಟಿ ಹೇಳುವುದು. ಕಾಮನ್ ಸಿವಿಲ್ ಕೋಡ್ನ ಮೂಲ ಒಂದೇ, ರಾಮ ಇಡೀ ದೇಶಕ್ಕೆ ಅಂತ. ರಾಮ ಅಂದರೆ ರಾಷ್ಟ್ರ, ರಾಮ ಅಂದರೆ ಧರ್ಮ, ರಾಮ ಅಂದರೆ ನ್ಯಾಯ, ರಾಮ ಅಂದರೆ ಸತ್ಯ. ನಮ್ಮ ಲಾ ಕಾಲೇಜಿನಲ್ಲಿ ವಿಶೇಷವಾಗಿ ಇವತ್ತೊಂದು ಕಾರ್ಯಾಗಾರ ನಡೀತಾ ಇದೆ. ಯೂನಿಫಾರ್ಮ್ ಸಿವಿಲ್ ಕೋಡ್, ಏಕರೂಪ ನ್ಯಾಯ, ನಾಗರಿಕ ಸಂಹಿತೆ, ಅದರ ವೇದಿಕೆ ಮೇಲೆ ಇರುವಂಥ ಎಲ್ಲ ಗಣ್ಯಾತಿ ಗಣ್ಯರೇ, ನಾನು ಮತ್ತು ವೆಂಕಟೇಶ್ ಕಿಣಿ ಇಬ್ಬರು ಸ್ವಲ್ಪ ಭಿನ್ನ. ಅವರಿಗೂ ಗೊತ್ತಿಲ್ಲ, ಕೋರ್ಟಿಗೆ ಎಷ್ಟು ಸಲ ಹೋದ್ರು, ಸಿವಿಲ್ ಕೋರ್ಟಿಗೆ ಸ್ವಲ್ಪ ಹೋಗಿದ್ದಾರೆ. ನಾನೊಂದು ಸ್ವಲ್ಪ ಕ್ರಿಮಿನಲ್ ಕೋರ್ಟಿಗೆ ಹೋಗಿದ್ದೇನೆ, ವಕೀಲಾಗಿ ಅಲ್ಲ. ಅಲ್ಲಿ ಕಟಕಟೆಯಲ್ಲಿ ನಿಲ್ಲಲಿಕ್ಕೆ ಸುಮಾರು 109 ಕೇಸುಗಳಾಗಿದೆ. ಹಾಗಾಗಿ ಒಂದು ಸ್ವಲ್ಪ ಅಷ್ಟೇ ಗೊತ್ತು ನನಗೆ. ಅಲ್ಲೊಬ್ಬರು ಜಡ್ಜ್ ಇದ್ದಾರೆ, ಒಂದಷ್ಟು ಲಾಯರ್ಸ್ ಇದ್ದಾರೆ, ತುಂಬ ಗಲಾಟೆ ಮಾಡ್ತಾ ಇರ್ತಾರೆ, ಅಂತಷ್ಟು ಗೊತ್ತು ನನಗೆ. ಸಿವಿಲ್ ಕೋಡ್ ನ್ಯಾಯ ಏಕರೂಪ ಸಂಹಿತೆ ಏನಿದೆ, ಇದು ಭಾರಿ ಅನಿವಾರ್ಯ ಅಂತ ಅನಿಸ್ತಾ ಇದೆ. ದೇಶಕ್ಕೆ ಸ್ವಾತಂತ್ರ್ಯ ಬಂದಂಥ ಸಂದರ್ಭದಲ್ಲಿ ಒಂದು ದೊಡ್ಡ ಗೊಂದಲ ನಿರ್ಮಾಣ ಆಯಿತು, ದೇಶ ವಿಭಜನೆ ಆಯಿತು. ಅದುವೇ ನಮಗೆ ಅತ್ಯಂತ ನೋವಿನ ಸಂಗತಿ. ಮತ್ತು ಇವತ್ತು ಜಗತ್ತಿಗೆ ಒಂದು ಭಯೋತ್ಪಾದಕರನ್ನು ತಯಾರು ಮಾಡುವಂಥ ಕೇಂದ್ರವನ್ನು ನಾವು ನಿರ್ಮಾಣ ಮಾಡಿ ಕೊಟ್ಟಿದ್ದೇವೆ. ಅದರ ಜೊತೆಗೆ ಉಳಿದಂತೆಲ್ಲ ಭಾಗಗಳು ಒಂದು ಅಂತ ಇತ್ತು. ಆದರೂ ಕಾಶ್ಮೀರ ಬೇರೆ ಅಂತ ಮಾಡಿದರು. 370ನೇ ವಿಧಿಯ ಮುಖಾಂತರ ಕಾಶ್ಮೀರ ಬೇರೆ ಅಂತಾಯಿತು. ಅದು ಎಲ್ಲವರೆಗೆ ತಲುಪಿತ್ತು ಅಂತ ಕೇಳಿದರೆ, ಈ ದೇಶದಲ್ಲಿ ಒಬ್ಬ ಪ್ರಧಾನಿ, ಆ ಭೂಭಾಗದಲ್ಲಿ ಒಬ್ಬ ಪ್ರಧಾನಿ, ಈ ಭಾಗದಲ್ಲಿ ಒಂದು ಸಂವಿಧಾನ, ಆ ಭಾಗದಲ್ಲಿ ಇನ್ನೊಂದು ಸಂವಿಧಾನ, ಈ ಭಾಗದಲ್ಲಿ ಒಂದು ಧ್ವಜ, ಆ ಭಾಗದಲ್ಲಿ ಒಂದು ಧ್ವಜ. ಒಂದು ವಿಚಿತ್ರ. ಈ ರೀತಿಯ ಸ್ಥಿತಿ ಜಗತ್ತಿನಲ್ಲಿ ಎಲ್ಲೂ ಇರಲಿಕ್ಕಿಲ್ಲ ಅಂತ ಅನಿಸುತ್ತೆ ನಮಗೆ. ಈಗ ಭಾರತೀಯ ಜನತಾ ಪಾರ್ಟಿ, ಹಿಂದೆ ಅದರ ರೂಪ ಭಾರತೀಯ ಜನಸಂಘ ಅಂತ, ಅದನ್ನು ಸ್ಥಾಪನೆ ಮಾಡಿದಂಥ ಭಾರಿಯೊಬ್ಬ ಶ್ರೇಷ್ಠ ರಾಜಕಾರಣಿ ಹೌದು, ರಾಷ್ಟ್ರಭಕ್ತನೂ ಹೌದು, ಡಾಕ್ಟರ್ ಶ್ಯಾಮ್ ಪ್ರಸಾದ್ ಮುಖರ್ಜಿ. ಅವರು ಅದರ ವಿರುದ್ಧ ಹೋರಾಟ ಮಾಡಿದರು. ಅವ್ರು ಹೇಳಿದರು, ಏಕ ದೇಶ ಮೇ ದೋ ಸಂವಿಧಾನ, ದೋ ವಿಧಾನ, ದೋ ಸಂವಿಧಾನ, ದೋ ನಿಶಾನ್ ನಹಿ ಚಲೇಂಗೆ ಅಂತ. ಈ ಒಂದು ದೇಶದಲ್ಲಿ 2 ಸಂವಿಧಾನ, 2 ಏನು ಧ್ವಜಗಳು, 2 ಪ್ರಧಾನ, ಅಂದರೆ 2 ಪ್ರಧಾನಮಂತ್ರಿಗಳು ಇರಲಿಕ್ಕೆ ಸಾಧ್ಯ ಇಲ್ಲ ಅಂತ. ಅದಕ್ಕೋಸ್ಕರ ಅವರು ಪ್ರಾಣ ಕೊಡಬೇಕಾಯಿತು. ಅಲ್ಲಿಂದ ಪ್ರಾರಂಭ ಆಗಿದೆ ಗೊಂದಲಗಳು ನಮ್ಮ ದೇಶದಲ್ಲಿ ಅಂತ ಅನಿಸಿದೆ. ಈಗ ಅನುಶ್ಯಾಮ್ ಹೇಳಿದ ಹಾಗೆ ಈ ದೇಶ ಒಂದು ಅಂತ ನಾವು ತಿಳಿಬೇಕಾಗಿತ್ತು. ದೇಶ ತುಂಡಾಗಿರುವಂಥದ್ದು ಮತೀಯ ಹಿನ್ನೆಲೆಯಲ್ಲಿ. ಕೊನೆ ಪಕ್ಷ ಉಳಿದಂಥ ಭಾಗ ನಾವೆಲ್ಲರೂ ಒಂದು ಅಂತ ಹೇಳುವಂಥ ಭಾವನೆ ಬರಬೇಕಾಗಿತ್ತು. ಅದು ಬರಲಿಲ್ಲ. ಅದಕ್ಕೋಸ್ಕರ ಈ ದೇಶದಲ್ಲಿ ಇದ್ದಂಥವರನ್ನು ಪುನಃ ಬಹುಸಂಖ್ಯಾತರು, ಅಲ್ಪಸಂಖ್ಯಾತರು ಅಂತ ಹೇಳುವಂಥ ಹೆಸರಿನಲ್ಲಿ ಇಲ್ಲಿ ಕಾನೂನುಗಳು ಬರಲಿಕ್ಕೆ ಪ್ರಾರಂಭ ಆಯಿತು. ನಿಧಾನವಾಗಿ ಬಹುಸಂಖ್ಯಾತ ಸಮಾಜ ಯಾವುದಿದೆ, ಹಿಂದೂ ಸಮಾಜ, ಅದನ್ನು ಮತಗಳ ಆಧಾರದ ಮೇಲೆ, ಜಾತಿಯ ಆಧಾರದ ಮೇಲೆ ಒಡೆಯುವಂಥ ಪ್ರಯತ್ನಗಳು ನಡೀತು. ಹೀಗೆ ಈ ದೇಶ ಇವತ್ತು ಒಂದಾಗಿ ಉಳಿಲಿಲ್ಲ. ಮೊನ್ನೆ ಒಂದು 2 ವರ್ಷದ ಹಿಂದೆ ಹಿಜಾಬಿನ ಒಂದು ಪ್ರಕರಣ ನಡೆಯಿತು. ಎಲ್ಲರೂ ಒಂದೇ ಇರಬೇಕು ಅಂತ ಹೇಳಿದರೆ ನಾವು ಬೇರೆ ಅಂತ. ಅದು ನಮ್ಮ ಮತ ಹಾಗೆ ಹೇಳುತ್ತೆ, ಅದಕ್ಕೋಸ್ಕರ ನಾವು ಬೇರೆ ಅಂತ. ಈ ದೇಶದಲ್ಲಿ ಇವತ್ತು ಜನಸಂಖ್ಯೆ ಜಗತ್ತಿನ ಅತ್ಯಂತ ಹೆಚ್ಚು ಜನಸಂಖ್ಯೆ ಇರುವಂಥ ದೇಶ ಇದು. 142.87 ಕೋಟಿ ಒಂದು 2 ತಿಂಗಳ ಹಿಂದೆ. ಎಲ್ಲ ಚೀನಾವನ್ನು ಕೂಡ ಹಿಂದಕ್ಕೆ ಹಾಕಿ ನಾವು ಭಯಂಕರ ವೇಗದಲ್ಲಿ ಮುಂದಕ್ಕೆ ಹೋಗ್ತಾ ಇದ್ದೇವೆ. ಆದರೆ ಆಗಿರುವಂಥದ್ದು ಎಂಥದ್ದು ಅಂತ ಕೇಳಿದರೆ, 1951ರಲ್ಲಿ 100ಕ್ಕೆ 97ರಷ್ಟು ಜನ ಹಿಂದೂಗಳು, 2.5% ಮುಸಲ್ಮಾನರು, 1/2% ಕ್ರಿಶ್ಚಿಯನ್ರಿದ್ದರು. ಈಗ ಅದು ವ್ಯತ್ಯಾಸ ಆಗಿ 97 ಇದ್ದದ್ದು 79 ಆಗಿದೆ. ಇದು ಸ್ವಲ್ಪ ದಿವಸ ಹಿಂದೆ ನಾನು ಹೇಳ್ತಾ ಇರುವಂಥ ಒಂದು 10 ವರ್ಷದ ಹಿಂದಿಂದ. ಅವರು 2.5 ಇದ್ದದ್ದು ಒಂದು 20 ಆಗಿಬಿಟ್ಟಿದ್ದಾರೆ. ಇವರು ಅರ್ಧ ಇದ್ದಂಥವ್ರು 5 ಆಗಿಬಿಟ್ಟಿದೆ. ಅಂದರೆ ಡೆಮೋಗ್ರಫಿಕಲ್ ಚೇಂಜ್ ಅಂತ. ಇದು ಭಾರಿ ಗಂಭೀರವಾಗಿ ಯೋಚನೆ ಮಾಡಬೇಕಾದಂಥ ಸಂಗತಿ. ಇಡೀ ಜಗತ್ತಿನ ಬೇರೆ ಬೇರೆ ದೇಶಗಳಲ್ಲಿ ಕೂಡ ಯಾವಾಗ ಈ ರೀತಿಯ ವ್ಯತ್ಯಾಸಗಳಾಯಿತೋ ಇಡೀ ದೇಶವೇ ವ್ಯತ್ಯಾಸ ಆಗಿಬಿಟ್ಟೆ. ಭಾರಿ ಜ್ವಲಂತ ಉದಾಹರಣೆ ಪಾಕಿಸ್ತಾನ. ಅಲ್ಲಿ ಬೇರೆ ಇಲ್ಲಿದ್ದಂಥ ಜನಗಳು ಮತಾಂತರ ಆಗಿ, ಅತ್ಯಾಚಾರಗಳಾಗಿ ಅವರ ಸಂಖ್ಯೆ ಹೆಚ್ಚಾದ ಕಾರಣ ಬೇರೆ ದೇಶವೇ ನಿರ್ಮಾಣ ಆಯಿತು. ಅದಕ್ಕೋಸ್ಕರ ಎಷ್ಟು ಮಕ್ಕಳು ಇರಬೇಕು, ಎಷ್ಟು ಹೆಂಡತಿ ಇರಬೇಕು, ಎಲ್ಲರಿಗೂ ಒಂದೇ ರೀತಿ ಇರಬೇಕು ತಾನೆ. ನಾವು ಹೇಳುವಾಗ ರಾಮಚಂದ್ರ ಪ್ರಭು ಶ್ರೀರಾಮಚಂದ್ರ ನಮಗೆ ಆದರ್ಶ ಅಂತ. ಅದು ಯಾರಿಗೆ ಆದರ್ಶ? ಎಲ್ಲರಿಗೂ ಆಗಬೇಕು ತಾನೆ. ಈ ದೇಶದ ಎಲ್ಲರಿಗೂ ಒಂದು ಆದರ್ಶ ಇರಬೇಕಲ್ಲ. ಹೀಗೆ ಈ ಕಾನೂನುಗಳ ತೊಡಕಿನಿಂದಾಗಿ ಅದು ಎಷ್ಟು ಆಗ್ಬೋದು ಅಂತ ಹೇಳೋದರ ಪರಿಣಾಮವಾಗಿ ಇವತ್ತು ಇಲ್ಲಿ ದೇಶದ್ರೋಹಿಗಳ ದೇಶ ವಿಭಜನೆಯ ಕೂಗು ಕೇಳ್ತಾ ಇದೆ. ಭಯೋತ್ಪಾದನೆ ಅದಕ್ಕೋಸ್ಕರ ಆಗಿರುವಂಥದ್ದು, ಭಾರಿ ದೊಡ್ಡ ಪ್ರಮಾಣದಲ್ಲಿ ಮತಾಂತರ ಅದಕ್ಕೋಸ್ಕರ ಆಗ್ತಾ ಇರುವಂಥದ್ದು. ಒಂದೊಂದು ಮನೆ ಒಡೆದಿದೆ, ಒಂದೊಂದು ಮನಸ್ಸು ಒಡೆದಿದೆ. ಹೀಗೆ ಇಡೀ ಸಮಾಜ ಒಂದಾಗಿ ನಾವು ನೋಡಬೇಕಾದಂಥ ಚಿಂತನೆಗಳು ಬದಲಾಗಿದೆ. ಈಗ ಮೊನ್ನೆ ಈಗ ಹೊಸ ಅಸೆಂಬ್ಲಿಯಲ್ಲಿ ಒಂದು ಕೂಗು ಎದ್ದಿದೆ, ಅಸೆಂಬ್ಲಿ ಒಳಗೆ ನಮಗೆ ಒಂದು ಪ್ರಾರ್ಥನಾ ಮಂದಿರ ಬೇಕು ಅಂತ. ಅಲ್ಲೇ ಹತ್ತಿರದಲ್ಲಿ ಅವರ ಲೆಜಿಸ್ಲೇಟಿವ್ ಎಂಥದ್ದು ಕೊಠಡಿಗಳೆಲ್ಲ ಇದೆ, ಅಲ್ಲಿ ಮಾಡ್ಬೋದು. ಇಲ್ಲ ಪಕ್ಕದಲ್ಲಿ ಶಿವಾಜಿನಗರದಲ್ಲಿ ಒಂದು ಮಸೀದಿ ಇದೆ. ನಾವು ಭಾರಿ ಪರಿಶುದ್ಧವಾದಂಥ ಒಂದು ಪವಿತ್ರವಾದಂಥ ಕೇಂದ್ರ ಅಂತ ನಾವು ವಿಧಾನಸಭೆಯನ್ನು ಅಥವಾ ಪಾರ್ಲಿಮೆಂಟನ್ನು ತಗೊಳ್ತೇವೆ. ಅದರೊಳಗೆ ನಮಗೆ ಒಂದು ಪ್ರಾರ್ಥನೆಗೆ ಒಂದು ಜಾಗ ಕೊಡಿ ಅಂತ ಕೇಳುವಲ್ಲಿವರೆಗೆ ಇದು ನಮ್ಮ ಹಕ್ಕು ಅಂತ ಹೇಳುವಲ್ಲಿವರೆಗೆ ಹೊರಟೋಗಿದೆ. ಅದಕ್ಕೋಸ್ಕರ ಒಂದು ರೀತಿ ರಿಲಿಜನ್ ಆಧಾರದ ಮೇಲೆ ಹೋಗದೆ ಇಡೀ ದೇಶ ಒಂದು, ನಾವೆಲ್ಲರೂ ಈ ಭಾರತೀಯರು ಈ ದೇಶಕ್ಕೆ ಸೇರಿದವರು ಅಂತ ಹೇಳುವಂಥ ಭಾವನೆ ಬರಬೇಕಾದಂಥ ಅವಶ್ಯಕತೆ ಇದೆ. ಇಲ್ಲಾಂತಾರೆ ಈ ದೇಶದಲ್ಲಿ ಇದ್ದಂಥವರು ದೇಶವನ್ನು ನೋಡಿದ್ದಾರೆ, ಇಡೀ ಜಗತ್ತು ನಮ್ಮನ್ನು ಹೊಡಿಲಿಕ್ಕೆ ನೋಡ್ತಾ ಇದೆ. ಮೊನ್ನೆ ನರೇಂದ್ರ ಮೋದಿಯವರು ಅಮೇರಿಕಕ್ಕೆ ಹೋದರು. ಅಮೇರಿಕಕ್ಕೆ ಹೋದಾಗ ಭಾರಿ ದೊಡ್ಡ ಸ್ವಾಗತ ಸಿಕ್ಕಿತ್ತು. ನಾವು ತಿಳ್ಕೊಂಡಿದ್ದೇವೆ ಅಮೇರಿಕದವರೆಲ್ಲ ನಮ್ಮನ್ನು ಭಾರಿ ಖುಷಿಯನ್ನು ನೋಡ್ತಾನೆ. ಇಲ್ಲ, ಅವರು ನಮ್ಮನ್ನು ಹೊಡಿಲಿಕ್ಕೆ ಏನು ಮಾಡಬೇಕು ಅದೆಲ್ಲವನ್ನು ಮಾಡ್ತಾರೆ. ಅವರು ಜಗತ್ತಿನ ಎಲ್ಲ ದೇಶಗಳು ಗೊತ್ತಿಲ್ಲ, ರಷ್ಯಾ ಏನು ಮಾಡ್ತಾರೆ ಗೊತ್ತಿಲ್ಲ, ಉಳಿದಂಥ ಎಲ್ಲ ದೇಶಗಳು ಈ ದೇಶವನ್ನು ಹೊಡಿಬೇಕು ಅಂತ ನೋಡ್ತಾರೆ. ಅದಕ್ಕೆ ಇದೆಲ್ಲವೂ ಕಾರಣ ಆಗುತ್ತೆ. ಅದಕ್ಕೆ ನಾವು ಒಟ್ಟಾಗಿರ್ತೇವ, ಆಗ ಮಾತ್ರ ಈ ದೇಶ ಇನ್ನಷ್ಟು ಅಭಿವೃದ್ಧಿಗೆ ಇರಲಿಕ್ಕೆ ಸಾಧ್ಯ. ಅದಕ್ಕೋಸ್ಕರ ಎಲ್ಲ ಭಾರಿ ಜನಗಳಿದ್ದೀರಾ ನೀವು ಇಲ್ಲಿ. ರಾಮಮೋಹನ್ ರಾಯರಂಥ ಭಾರಿ ಹಿರಿಯರು, ಅವರ ನೇತೃತ್ವದಲ್ಲಿ ಒಂದು ರೀತಿ ನಡೀತಾ ಇದೆ ಅಂತ ಅನಿಸ್ತದೆ ನನಗೆ. ಯಾಕೆ ಅವರು ಹಿರಿಯರು ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಅಂತ ಹೇಳಿದರೆ 86 ವಯಸ್ಸು ಅವರಿಗೀಗ. ನನಗನ್ಸರಿ ಕಳೆದ ಒಂದು 70 ವರ್ಷಗಳಿಂದ ಅವರು ಒಬ್ಬ ನ್ಯಾಯವಾದಿಯಾಗಿ ಇಲ್ಲಿ ಕೆಲಸ ಮಾಡ್ತಾಯಿದ್ದಾರೆ. ಯಾಕೆ ಯಶಸ್ಸು ಬಂದಿದೆ ಅವರಿಗೆ ಅಂತ ಕೇಳಿದರೆ ಪ್ರಾಮಾಣಿಕವಾಗಿ ಕೆಲಸ ಮಾಡಿದರು ಅಂತ. ಈ ಪ್ರಾಮಾಣಿಕತನ ಇವತ್ತು ಇಡೀ ದೇಶದಲ್ಲಿ ತೊಂದರೆಗೆ ಒಳಗಾಗಿರುವಂಥದ್ದು. ಅದಕ್ಕೆ ಪ್ರಾಮಾಣಿಕವಾಗಿ ಕೆಲಸ ಮಾಡಿದರೆ ಜನ ಅವರನ್ನು ನಂಬ್ತಾರೆ ಅಂತ, ಕಾನೂನನ್ನು ಒಪ್ಕೊಳ್ತಾರೆ ಅಂತ. ಅದಕ್ಕೋಸ್ಕರ ಕಾನೂನನ್ನು ರಚಿಸುವಂಥದ್ದು ಅದರಲ್ಲಿ ಒಂದು ಪಾತ್ರ ಅದು ಈ ಜನಗಳದ್ದು ಇದೆ. ಸರ್ಕಾರ ಅದಕ್ಕೋಸ್ಕರ ಜನಗಳ ಹತ್ರ ಕೇಳಿದ್ದಾರೆ, ಯೂನಿಫಾರ್ಮ್ ಸಿವಿಲ್ ಕೋಡ್ ನಾವು ತರ್ತಾ ಇದ್ದೇವೆ, ಅದಕ್ಕೆ ನಿಮ್ಮ ಅಭಿಪ್ರಾಯ ಏನು ಅಂತ. ಭಾರಿ ಒಳ್ಳೆಯದು ಅಂತ ಹೇಳಿದರೆ ವಿವೇಕಾನಂದ ವಿದ್ಯಾವರ್ಧಕ ಸಂಘ ಹೀಗಿದ್ದ ಅನೇಕ ಯೋಜನೆಗಳನ್ನು ಮಾಡ್ತಾ ಹೋಗ್ತದೆ. ಅದಕ್ಕೆ ರಾಜ್ಯದಲ್ಲೇ ಮೊದಲ ಬಾರಿಗೆ ವಿವೇಕಾನಂದ ಲಾ ಕಾಲೇಜ್ ರವೀಂದ್ರರ ನೇತೃತ್ವದಲ್ಲಿ ಅದನ್ನು ತಗೊಳ್ತಾ ಇದೆ. ಅದಕ್ಕೆ ನಿಮ್ಮ ಅಭಿಪ್ರಾಯ, ಜನಗಳ ಅಭಿಪ್ರಾಯ. ಅವ್ರು ಈಗಾಗಲೇ ಹೇಳಿದರು 75 ವರ್ಷದಲ್ಲಿ ಹಿಂದಿದ್ದಂಥ ಜನ ಅಲ್ಲ ಇವತ್ತು 4ನೇ ತಲೆಮಾರು ಅಂತ ಹೇಳಿದರು ರಾಮಮೋಹನ್ ರಾಯರು. ಅದಕ್ಕೋಸ್ಕರ 4ನೇ ತಲೆಮಾರಿನ ಜನ ನಾವೇನು ಯೋಚನೆ ಮಾಡ್ತೇವೆ, ನಾವು ಒಟ್ಟಾಗಿರಬೇಕಾದ್ರೆ ಒಂದಾಗಿರಬೇಕಾದ್ರೆ ಒಂದು ತರಗತಿಯಲ್ಲಿ ನಾವು ಒಟ್ಟಾಗಿರಬೇಕಾದ್ರೆ, ಭಾರಿ ದೂರದ್ದು ಬೇಡ, ಒಂದು ತರಗತಿಯಲ್ಲಿ ಅಥವಾ ನನ್ನ ಊರಿನಲ್ಲಿ ನಾವೆಲ್ಲರೂ ಒಟ್ಟಾಗಿ ಇರಬೇಕು ಅಂತ ಆದರೆ ಅದಕ್ಕೆ ಏನಾಗಬೇಕು, ಯಾವ ರೀತಿಯ ಕಾನೂನು ರಚನೆ ಆಗಬೇಕು ಅಂತ ಹೇಳುವಂಥ ದೃಷ್ಟಿಯಿಂದ ನೀವೆಲ್ಲರೂ ಯೋಚನೆ ಮಾಡ್ತೀರಾ. ಅವರು ಒಂದಷ್ಟು ವಿಷಯಗಳನ್ನು ಹೇಳ್ತಾರೆ. ಭಾರಿ ಹಿರಿಯ ನ್ಯಾಯವಾದಿಗಳೆಲ್ಲ ಇದ್ದೀರ ಇಲ್ಲಿ. ಎಲ್ಲವನ್ನು ನೋಡಿಕೊಂಡು ದೇಶವನ್ನು ಕಣ್ಣ ಮುಂದೆ ಇಟ್ಟುಕೊಂಡು, ಯಾವುದು ವ್ಯಕ್ತಿಗತ ಇಲ್ಲ, ದೇಶವನ್ನು ಕಣ್ಣ ಮುಂದೆ ಇಟ್ಟುಕೊಂಡು ನಾವೇನು ಮಾಡ್ಬೋದು, ಯೂನಿಫಾರ್ಮ್ ಸಿವಿಲ್ ಕೋಡ್ ತರುವಂಥ ದೃಷ್ಟಿ ನಮ್ಮ ಸಜೆಷನ್ಸ್ ಎಲ್ಲ ಏನೇನು ಅಂತ ಹೇಳುವುದಕ್ಕೆ ಒಂದು ಅವಕಾಶ ಮಾಡಿಕೊಟ್ಟಿದ್ದೇವೆ. ಆ ಅವಕಾಶವನ್ನು ತಾವೆಲ್ಲರೂ ಉಪಯೋಗ ಮಾಡಿಕೊಳ್ಳಿ. ಎಲ್ಲರಿಗೂ ಶುಭವಾಗಲಿ. ಒಂದೇ ಮಾತರು.
Thank you, sir. When Uniform Civil Code is applied to other areas, why can't it be implemented to the personal laws? Why can't we have a uniformity of laws is $1 million question. As Sir mentioned, this conference aspires to explore the role of Uniform Civil Code in newer dimension and in the light of the issues currently faced by the society. Thank you so much for your address, sir. Now I request the President of the program, Dr. Parladka, the President of Vivekananda Vidyavardhaka Sangha, to hand over memento to proud alumnus and Senior Advocate, Dr. Aruna Sharma. Thank you. I would request my colleague Sri Lakshmikanta A, Assistant Professor of Political Science, to propose vote of thanks.
ಎಲ್ರಿಗೂ ಶುಭ ಮುಂಜಾನೆ. ಕಳೆದ 35 ವರ್ಷಗಳಿಂದ ವಿವೇಕಾನಂದ ಕಾನೂನು ಮಹಾವಿದ್ಯಾಲಯ ಮೌಲ್ಯಯುತ ಶಿಕ್ಷಣದ ಜೊತೆಗೆ ಗ್ರಾಮ ಅಥವಾ ಸಮಾಜದಲ್ಲಿ ವಿವಿಧ ರೀತಿಯ ಆಗುಹೋಗುಗಳಿಗೆ ಸ್ಪಂದಿಸುವ ಕೆಲಸವನ್ನು ಮಾಡ್ತಾ ಇದೆ. ಗ್ರಾಮ ವಿಕಾಸ ಇರ್ಬೋದು, ವಿವೇಕ ಸಂಜೀವನಿ ಇರ್ಬೋದು, ಅಥವಾ ಸಾಮಾನ್ಯ ಜನರಿಗೆ ಬೇಕಾದಂತಹ ಕಾನೂನಿನ ಮಾಹಿತಿ ಇರ್ಬೋದು, ಇದನ್ನು ನಿರಂತರವಾಗಿ ಕೊಡುವಂಥ ಕೆಲಸವನ್ನು ಮಾಡ್ತಾ ಬರ್ತಾ ಇದೆ. ಇಂದು ದೇಶದಲ್ಲಿ ಒಂದು ದೇಶ ಒಂದು ಕಾನೂನು ಅಂತ ಹೇಳುವಂತಹ ತತ್ವದ ಅಡಿಯಲ್ಲಿ ಏಕರೂಪ ನಾಗರಿಕ ಸಂಹಿತೆಯನ್ನು ಜಾರಿಗೊಳಿಸುವ ವಿಚಾರ ಚರ್ಚೆಯಲ್ಲಿದೆ. ಈ ನಿಟ್ಟಿನಲ್ಲಿ ಇದರ ಬಗ್ಗೆ ವಿಶೇಷ ಕಾಳಜಿಯನ್ನು ವಹಿಸಿರುವಂತಹ ನಮ್ಮ ಕಾಲೇಜು ಅದರ ಕುರಿತಾದ ವಿಚಾರ ಸಂಕಿರಣವನ್ನು ಏರ್ಪಡಿಸಿ ಆ ಮೂಲಕ ಮಾಹಿತಿಯ ಪೂರಣವನ್ನು ನೀಡುವಂಥ ಕೆಲಸವನ್ನು ಮಾಡ್ತಾ ಇದೆ. ಏಕರೂಪ ನಾಗರಿಕ ಸಂಹಿತೆ ಕುರಿತ ರಾಷ್ಟ್ರೀಯ ವಿಚಾರ ಸಂಕಿರಣವನ್ನು ದೀಪ ಬೆಳಗುವ ಮೂಲಕ ಉದ್ಘಾಟಿಸಿ ಏಕರೂಪ ನಾಗರಿಕ ಸಂಹಿತೆಯ ಕುರಿತಾಗಿ ತಿಳಿಸಿದ ಇಂದಿನ ಕಾರ್ಯಕ್ರಮದ ಉದ್ಘಾಟಕರಾದ ಡಾಕ್ಟರ್ ಕೆ.ಸಿ. ಸಣ್ಣಿ, ರಾಷ್ಟ್ರೀಯ ಕಾನೂನು ಮಹಾವಿದ್ಯಾಲಯದ ನಿಕಟಪೂರ್ವ ಕುಲಪತಿಗಳು, ಇವರಿಗೆ ತುಂಬು ಹೃದಯದ ಧನ್ಯವಾದಗಳನ್ನು ಕೋರ್ತಾ ಇದ್ದೇನೆ. ನಮ್ಮ ಇಂದಿನ ಕಾರ್ಯಕ್ರಮದ ಅಧ್ಯಕ್ಷತೆಯನ್ನು ವಹಿಸಿ ಏಕರೂಪ ನಾಗರಿಕ ಸಂಹಿತೆಯ ಆಶಯವನ್ನು ತಿಳಿಸಿದ ನಮ್ಮೆಲ್ಲರ ಮಾರ್ಗದರ್ಶಕರು ವಿವೇಕಾನಂದ ವಿದ್ಯಾವರ್ಧಕ ಸಂಘದ ಅಧ್ಯಕ್ಷರಾದ ಡಾಕ್ಟರ್ ಪ್ರಭಾಕರ್ ಭಟ್ ಸರ್, ಇವರಿಗೂ ಆತ್ಮೀಯವಾದ ಧನ್ಯವಾದಗಳನ್ನು ಅರ್ಪಿಸ್ತಾ ಇದ್ದೇನೆ. ಏಕರೂಪ ನಾಗರಿಕ ಸಂಹಿತೆ ಕುರಿತು ಮಾಹಿತಿ ನೀಡಿ ಮುಂದೆ ನಡೆಯಲಿರುವ ವಿಚಾರಗೋಷ್ಠಿಯಲ್ಲಿ ವಿಚಾರ ಮಂಡಿಸಲಿರುವ ಪುತ್ತೂರಿನ ಹಿರಿಯ ನ್ಯಾಯವಾದಿ ಶ್ರೀ ಎಂ ರಾಮಮೋಹನ್ ರಾವ್ ಇವರಿಗೂ ಸಹ ತುಂಬು ಹೃದಯದ ಧನ್ಯವಾದಗಳನ್ನು ಅರ್ಪಿಸ್ತಾ ಇದ್ದೇನೆ. ಇಂದಿನ ಈ ವಿಚಾರ ಸಂಕಿರಣದಲ್ಲಿ ಏಕರೂಪ ಕಾಯ್ದೆಯ ಕುರಿತು ವಿವರಿಸಿದ ಹೈಕೋರ್ಟ್ ವಕೀಲರು ಹಾಗೂ ನಮ್ಮ ಮಹಾವಿದ್ಯಾಲಯದ ಹೆಮ್ಮೆಯ ಹಿರಿಯ ವಿದ್ಯಾರ್ಥಿ ಗೌರವಾನ್ವಿತ ಅರುಣ್ ಶ್ಯಾಮ್ರವರಿಗೂ ತುಂಬು ಹೃದಯದ ಧನ್ಯವಾದಗಳು. ನಮ್ಮ ಸಂಸ್ಥೆಯ ಆಡಳಿತ ಮಂಡಳಿ ಅಧ್ಯಕ್ಷರಾಗಿ ನಮ್ಮ ಸಂಸ್ಥೆಯ ಬೆಳವಣಿಗೆ, ವಿದ್ಯಾರ್ಥಿಗಳ ಸಾಧನೆಗೆ ಸದಾ ಪ್ರೋತ್ಸಾಹಿಸುತ್ತಿರುವ ಶ್ರೀಯುತ ಸುರೇಂದ್ರ ಕ್ರೀನಿಯವರಿಗೆ ಅಭಿನಂದನೆಗಳು. ಕಾನೂನು ಶಿಕ್ಷಣದ ಜೊತೆಗೆ ವಿವೇಕಾನಂದ ಕಾನೂನು ಮಹಾವಿದ್ಯಾಲಯದ ವಿದ್ಯಾರ್ಥಿಗಳು ಸಮಾಜದ ಆಗುಹೋಗುಗಳಿಗೆ ಸ್ಪಂದಿಸುವ ಪ್ರಜ್ಞಾವಂತ ನಾಗರಿಕರಾಗಬೇಕು ಎನ್ನುವ ಆಶಯದೊಂದಿಗೆ ಸದಾ ಮಾರ್ಗದರ್ಶನವನ್ನು ಮಾಡುವ ನಮ್ಮ ಮಹಾವಿದ್ಯಾಲಯದ ಸಂಚಾಲಕರಾದ ಶ್ರೀ ವಿಜಯನಾರಾಯಣ್ ಕೆ.ಎಂ. ಇವರಿಗೂ ಧನ್ಯವಾದಗಳು. ನಮ್ಮ ಇಂದಿನ ಈ ಕಾರ್ಯಕ್ರಮದ ರೂವಾರಿ, ಸದಾ ಅರ್ಥಪೂರ್ಣ ಕಾರ್ಯಕ್ರಮಗಳಿಗೆ ಸಾಥ್ ಕೊಡುವ ನಮ್ಮೆಲ್ಲರ ಮಾರ್ಗದರ್ಶಕರು ಹಾಗೂ ನಮ್ಮ ಮಹಾವಿದ್ಯಾಲಯದ ಕಾನೂನು ವಿಭಾಗದ ನಿರ್ದೇಶಕರಾಗಿರುವ ಡಾಕ್ಟರ್ ಬಿ.ಕೆ. ರವೀಂದ್ರ ಸರ್ ಇವರಿಗೂ ಧನ್ಯವಾದಗಳು. ನಮ್ಮ ಮಹಾವಿದ್ಯಾಲಯದ ಎಲ್ಲ ರೀತಿಯ ವಿದ್ಯಾರ್ಥಿ ಸ್ನೇಹಿ ಚಟುವಟಿಕೆಗಳಿಗೆ ಸದಾ ಪ್ರೋತ್ಸಾಹವನ್ನು ನೀಡುವ ನಮ್ಮ ಮಹಾವಿದ್ಯಾಲಯದ ಪ್ರಾಂಶುಪಾಲರಾದ ಶ್ರೀಮತಿ ಅಕ್ಷತಾ ಎ.ಪಿ. ಮೇಡಮ್ ರವರಿಗೂ ಅಭಿನಂದನೆಗಳು. ಅದೇ ರೀತಿ ವೇದಿಕೆಯ ಮುಂಭಾಗದಲ್ಲಿ ಮುಂದಿನ ವಿಶೇಷ ವಿಚಾರಗೋಷ್ಠಿಗಳನ್ನು ನಡೆಸಿಕೊಡ್ಲಿಕ್ಕಿರುವಂತಹ ಎಲ್ಲ ಆಹ್ವಾನಿತ ಸಂಪನ್ಮೂಲ ವ್ಯಕ್ತಿಗಳಿಗೂ ತುಂಬು ಹೃದಯದ ಧನ್ಯವಾದಗಳು. ಈ ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ಉಪಸ್ಥಿತರಿರುವ ವಿವೇಕಾನಂದ ವಿದ್ಯಾವರ್ಧಕ ಸಂಘದ ಆಡಳಿತ ಮಂಡಳಿ ನಿರ್ದೇಶಕರಿಗೆ, ವಿವಿಧ ವಿದ್ಯಾಸಂಸ್ಥೆಗಳ ಅಧ್ಯಕ್ಷರಿಗೆ, ಆಡಳಿತ ಮಂಡಳಿ ಸದಸ್ಯರಿಗೆ, ಪ್ರಾಂಶುಪಾಲರುಗಳಿಗೆ, ಬೋಧಕ ವೃಂದದವರಿಗೆ ತುಂಬು ಹೃದಯದ ಧನ್ಯವಾದಗಳನ್ನು ಅರ್ಪಿಸ್ತಾ ಇದ್ದೇನೆ. ಈ ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ಉಪಸ್ಥಿತರಿರುವ ಪುತ್ತೂರು ವಕೀಲರ ಸಂಘದ ಅಧ್ಯಕ್ಷರು, ಎಲ್ಲ ನ್ಯಾಯವಾದಿಗಳಿಗೆ, ವಿವಿಧ ಜಿಲ್ಲೆಗಳ ತಾಲೂಕುಗಳ ವಕೀಲರ ಸಂಘದ ವಿವಿಧ ಪದಾಧಿಕಾರಿಗಳಿಗೆ ಹಾಗೂ ನ್ಯಾಯವಾದಿಗಳಿಗೆ ತುಂಬು ಹೃದಯದ ಧನ್ಯವಾದಗಳನ್ನು ಸಲ್ಲಿಸ್ತಾ ಇದ್ದೇನೆ. ಈ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ಅತಿಥಿಗಳಾಗಿ ಆಗಮಿಸಿರುವ ಕೇರಳ ಹಾಗೂ ದಕ್ಷಿಣ ಕನ್ನಡ ಜಿಲ್ಲೆಯ ವಿವಿಧ ವಿದ್ಯಾಸಂಸ್ಥೆಗಳ ಪ್ರತಿನಿಧಿಗಳಿಗೂ ತುಂಬು ಹೃದಯದ ಧನ್ಯವಾದಗಳನ್ನು ಅರ್ಪಿಸ್ತಾ ಇದ್ದೇನೆ. ನಮ್ಮ ಕಾಲೇಜಿನ ಆಡಳಿತ ಮಂಡಳಿ ಸದಸ್ಯರಿಗೆ, ಶಿಕ್ಷಕ ರಕ್ಷಕ ಸಂಘದ ಎಲ್ಲ ಪದಾಧಿಕಾರಿಗಳಿಗೆ, ನಮ್ಮ ಕಾಲೇಜಿನ ಹಿರಿಯ ವಿದ್ಯಾರ್ಥಿ ಸಂಘದ ಸದಸ್ಯರಿಗೆ ಹಾಗೂ ನನ್ನೆಲ್ಲ ಬೋಧಕ ಹಾಗೂ ಬೋಧಕೇತರ ಸಿಬ್ಬಂದಿಗಳಿಗೆ, ಜೊತೆಗೆ ನನ್ನ ಆತ್ಮೀಯ ವಿದ್ಯಾರ್ಥಿಗಳಿಗೆ ತುಂಬ ಹೃದಯದ ಧನ್ಯವಾದಗಳನ್ನು ಅರ್ಪಿಸ್ತಾ ಇದ್ದೇನೆ. ಈ ಕಾರ್ಯಕ್ರಮವನ್ನು ಪ್ರಸ್ತುತಪಡಿಸುವ ಜೊತೆಗೆ ಸಮಾಜದ ತಳಮಟ್ಟದ ವ್ಯಕ್ತಿಗೂ ತಲುಪಿಸುವ ಕೆಲಸವನ್ನು ಮಾಡಲಿರುವ ನಮ್ಮ ಎಲ್ಲ ಪತ್ರಿಕಾ ಬಂಧುಗಳಿಗೆ, ಟಿ ವಿ ಮಾಧ್ಯಮದವರಿಗೆ ಕಾಲೇಜಿನ ಪರವಾಗಿ ತುಂಬ ಹೃದಯದ ಧನ್ಯವಾದಗಳನ್ನು ಅರ್ಪಿಸ್ತಾ ಇದ್ದೇನೆ. ಕೊನೆಯದಾಗಿ ಈ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ಪ್ರತ್ಯಕ್ಷ ಹಾಗೂ ಪರೋಕ್ಷವಾಗಿ ಸಹಕರಿಸಿದ ಎಲ್ಲ ಆತ್ಮೀಯ ಬಂಧುಗಳಿಗೆ ತುಂಬ ಹೃದಯದ ಧನ್ಯವಾದಗಳನ್ನು ಸಲ್ಲಿಸ್ತಾ ಇದ್ದೇನೆ.
Thank you, sir. The formal program comes to an end now. After 10 minutes of break, we will gather here again for the technical session. We have a technical session after 10 minutes break. Guest speakers would address us on different topics related to Uniform Civil Code. Now the audience can take 10 minutes tea break. Light refreshment is arranged in a college corridor in the first floor. And once again, my heartfelt gratitude for all the dignitaries and guests for being with us for formal function. Thank you. Let's assemble here exactly at 11:15.
Our technical session is about to begin. Good morning, everyone. A warm welcome to all for the technical session. I, Sri Raksha, Assistant Professor of Law, will be hosting today's technical session. May I request the moderator of today's technical session, Dr. B.K. Ravindra, Director of Legal Studies, to escort the guest speakers onto the stage. I take this pleasure of inviting the resource persons and moderator, Sri Rammohan Rao, Senior Advocate, Puttur, Dr. Sairam Bhatt, Professor of Law, National Law School of India, University, Bangalore, Dr. K.R. Aital, Professor of Law, Presidency University, and former Dean, Faculty of Law, Karnataka University, Dharwad, and Dr. K.C. Sunny, Professor and Dean, Central University of Kerala. And the moderator of today's session, Dr. B.K. Ravindra Sir, Director of Legal Studies, Vivekananda Law College, Puttur. Once again, a warm welcome to you all. The speaker of the first session of today's program is Sri M. Rammohan Rao. He is one among the senior advocate of Puttur. Graduating from Kishan Chand Chellaram Law College, Mumbai, Sri Ram Mohan Rao Sir started his law practice in Mangalore under the guidance of Sri U.R. Kinney. Since 1962, he has been practicing advocacy and has been recognized as one of the popular advocates of this city. In 2009, he authored a book related Kumki Right. He participated as a judge in national level moot court competitions, has experience of working with JCI Lions Club. He is also a member of our college advisory committee. It's a pleasure for us to have him here with us today. Today, Sri M. Rammohan Rao Sir will speak on the topic Uniform Civil Code. We are much awaited to listen to his speech on this topic. Over to you, sir.
Respected members on the dais, younger generation of law students, members of the press, some of my colleagues also. Now, the directive principles only say endeavor as much as possible to implement Uniform Civil Code on certain subjects. The word used by Dr. Ambedkar was that implement it as much as possible, taking into consideration the condition of India then prevailing. We have progressed a lot, financially, economically, and even in the international level. Therefore, the country's integrity today faces two problems, external, internal. In this session, we are concerned with the internal problems. Our country is a country of unity in diversity. The diversity today is stressed to certain limit that based on religion, language, region, we are trying to enforce our rights. They are based on also language. They are also based on religion. Now, these result in internal disharmony. So therefore, we have to think about a common civil law for enforcement of our rights. Who will be the citizen of India? He will know what law, by which law he will be governed. You may be interested in knowing that so far as our country is concerned, there are Portuguese laws prevailing in certain parts, French law prevailing in certain parts, tribal law prevailing in certain parts, and the rest, some laws enacted for Hindus, some law enacted for Mohammedans, and Parsis have a separate law for themselves concerning marriage and other relations. You may be aware that if a person is born and brought up in Pondicherry, the French protectorate, which was made over to India in about 1954 or so, they were electing 2 representatives to the French government, parliament. So they had their own law. And when the area was made over to India, India recognized their law as not to be interfered with. So that continues even today, the law. And in one of the Karnataka High Court judgment, this question came up for consideration, touching upon the marriage of 2 persons who were born and brought up in Pondicherry, but got married, got registered under the Special Marriage Act, and they had a problem of divorce. And the French law, according to me, was more interesting. Wife or husband, they started a complaint under the family law before the Bangalore court. And there, a division bench has held what law is applicable by applying the French law, which is something unique as I find it. Both had complaints against each other. And divorce was inevitable. But under Indian law, you will find that whoever comes to court, if he is not able to prove the grounds, he is presumably rejected. What's use? But under French law, Article 240 to 245 of that French law, the judge had even then the option to say that, all right, we will grant you divorce, because it is incompatibility. We introduced incompatibility under section 13b, etc. of the Indian marriage laws. So, and on incompatibility, the judge wanted to grant a divorce or gave a divorce was without reasoning. He did not disclose the reasons at all. Whereas our law says, before a man is condemned, give opportunity. Without hearing, don't pass an order. But that law, to that extent, I feel that where incompatibility is found out from the proceedings before the court, it is better that you give a divorce rather than compel 2 incompatible persons to plow the field together. This is one aspect. The second aspect on which I am touching is the Schedule 7 of the Indian Constitution deals with certain aspects only, marriage, divorce, etc., etc. I will come to that later. But TP Act is also included therein. Why we implemented it? Property rights. Transfer of properties are governed by that law. Why not cover it by implementing the law so far as the parties are concerned, irrespective of the personal law by which they are governed? Tribal law and our law contained several socialistic, revolutionary ideas implemented by law. For example, the Sati Act, which was a menace to then widows or wives, younger generation. They were compelled, for reasons beyond their control, sacrificed on the altar or the pyre of the husband. That was eliminated. Several marriages on the Arya Samaj Act, intercaste marriages, interreligious marriages, were validated. Then came the Parsi law. They were validated to some extent. Then, of course, there was the Muslim law, Shariat Act, which did not immediately allow a divorce even to a woman. discrimination between man and woman. Even otherwise in other law, certain prohibitory relationships were there. Within a particular degrees, you can't get married. This is because a concept was there that purity of blood, especially the royal families, was the concept which flowed from Egypt. But all the laws prohibit certain degree of relationship within which marriage can take place. Tribal people had polyandry, then polygamy. Ultimately, universally it is accepted that monogamy is the order of the day, but not applicable to particular community. Should we allow that or unite all our citizens under one law of monogamy? Because polygamy will result in more and more marriages. The law says one can marry up to 4 times. 5th one is only irregular. But it is a religious, is it religion or a practice followed? So when it comes to the particular section based on religion, what we are trying to achieve is, we are trying to streamline the practice, not religion. Your right to practice religion is not prohibited to attract Article 26. But what is sought to be prohibited is a particular practice, prevent it. And one man, one wife would be more feasible, perhaps more in the sense of regulating our population as well, because we are on a very progressive path, internationally recognized as economically, financially, we have developed a lot. What was the law sought to be implemented in when the constitution was framed need not be applied today. There have been vast changes. So with these vast changes, perhaps implement the law as it needs the order of the day. Regulate population also, because more people are numbered, added. You have to grow more food. Our capacity may be limited. We have to provide employment to the vast majority of youngsters like you. Maybe you are in the legal field now, but there are similar youngsters who are in various fields. After graduating, they find that they don't have a job. From that point of view, perhaps, regulation of or control of population is also one of the essential points. Now coming to the subject, I already said French have their own law in Pondicherry. You may also remember that French government, France was once dominated by the kings. There was a revolution. Napoleon led that revolution. And thereafter, they have adopted a law where religion is not part of the government level at all. Religion is independent. You practice it subject to law and order. So, that would be a proper approach in the applicability of religious law by the government, allowing practices which are not repugnant to law and order situation, so also for the development of the nation with the uniform civil code. That's why I feel that that sort of approach is needed. The second aspect is Portuguese. Goa. Goa was liberated in the year 1962 or so, Operation Vijay. And Portuguese abandoned Goa because they were not able to control the people. We took over. But we had a contract with the people there by legislation, enabling them their civil code. Today, what we are pressing for is the same law. Common civil code is applicable even today in Goa, irrespective of the religion. Why not have it? There cannot be objection when a small bit of our India is following that practice without any remorse, without affection, without disaffection. and without social turmoil. Then we have annexation of tribal areas. I already pointed out that. My point is, when annexation took place, we had assured them that your laws will be, your tribal laws will be honored. Considering the time at that, should we continue it even today to discriminate amongst Hindus? The tribal people are not governed by any Hindu law at all, Hindu acts, I am sorry. Whereas scheduled castes are governed by that law. Why this disparity and discrimination? We have not been able to comprehend. So also, I would go to the root cause of enacting so many laws so far as Hindus are concerned, based on succession, marriage, etc., etc. Should this be codified and made applicable under a common marriage law for all the people, irrespective of their caste, creed, or religion? That takes us to the next point. You may also note that in India there are more than 9 marriage laws, I think, in practice. If you go to Sikkim, you can't acquire a property there because they are governed by their own law. We have given them the assurance. Should that be changed? Or should it be prolonged or postponed is one of the aspects. And on these matters, since these lists are in the concurrent list, state governments have their own right to make the law. I will point out the inequality. As you are all well aware, so also my friend, in 1976, the Kerala passed a law called as Hindu Act of 1976, abolishing the rights so far as Hindus are concerned for persons to be born thereafter. I think it is 1176 or so. Well, under that system, one law which was also abolished was abolition of rights. The Aliya Santana law, the Marma Kattayam law, streamlined. So this law applied there so far as the people governed by that law is concerned. Well and good. State had the power. But my problem which I faced was joint family system was abolished thereunder. That joint family system is not abolished in Karnataka. So what is the position of a joint family which has properties both in Kerala and Karnataka? Is it lex loci stand? The law of the land will prevail. For Karnataka there is a joint family under Kerala law, but not under Kerala law for enforcement. So in this background perhaps where there is a confusion, inequality or clarity, no want of clarity, we should have a uniform civil code. Then, as I said earlier, one man, one marriage. And family law, should we not take into account the provision under the Income Tax Act which says that there is some exemption from tax if a SSE takes the benefit of a joint family system? Does it depend on religion or mere classification, or a benefit for the tax payer only? Should it be extended to other people also, not necessarily to joint Hindu family, or classified broadly as joint family? Then there was a law, you are all well aware, maintenance payable under the Criminal Procedure Code, section 125. Maintenance payable under the personal law, Muslims. A divorced wife will be entitled to maintenance only during the period of iddat. Thereafter, no. Personal law, no. Who should provide the maintenance for the wife who has become a destitute? Supreme Court gave a ruling. struck down or altered by later legislation. Today the question is, when the law has been upheld in a later ruling where triple talaq has been negatived because it is unreasonable, should you not have a common marriage law for everybody? The second aspect is, even amongst Hindus, there is a belief and a custom and a practice that moment a girl is married, she goes outside that family, from that of her parents to that of the husband. And she was provided maintenance, wisely or otherwise, when her husband died, to be maintained by husband's family with the maintenance only. Later on, it was changed to some property allotment of the husband for maintenance, later on made absolute, and now she also inherits rights under the Hindu Succession Act, which applies to even Aliya Santana people also. So far as the Aliya Santana is concerned, 1949 Act provides certain mode of partition, and in 61 there is an amendment which says that per capita shall be granted but make it absolute. That means inheritance is not confined to a family custom but concentrating on the husband and his dependent children. Matriarchal system is abolished and the right of management is also changed. So there it needs clarity and uniform in implementation of the law. Now, Section 6 of the Hindu Succession Act, which gives the right to daughter to be treated on par with the son because he is a co-partner. Should we also amend the co-partnership law, or the inheritance right to a daughter, because conferring such a right, I have noticed that in the course of my practice, disputes, quarrels between brother and sister, it should be modified, altered by a common law, perhaps is the only answer. I am not here advocating a proposition that ladies should not be given any right at all. They should be, but how? In what manner can you modify it in a civil law? Now concentrate on your mind on addressing questions to the Law Commission on this point, Parliamentary Commission, I am sorry. When we go to the question of inheritance, each law provides different type of inheritance. Indian Succession Act was made applicable to Christians, whereunder the wife automatically gets more right than children. And when we go to other law, there is a inequality. Females getting half right of what the son gets. Widow or widows together get only 1/8 share. This is the Mohammedan law of inheritance. And in the same law we find there is something like called a deathbed gift. Oral will by a dying person. Should you not alter this law of a deathbed gift not supported by a document to be proved in a court of law between warring factions? Make it compulsory. And this compulsoriness, according to me, should also extend to the law relating to wills. Of course, the present law is that will need not be registered, need not be something different from. Make it authentic, because in many cases we find wills cropping up after the death, bearing either signature or thumb mark made use of on a previous occasion when the man was even unable to understand what he bequeathed. So, either a gift or a will, etc., it would be preferable to have it registered, irrespective of the religion, caste, creed. Now I have already pointed out about the differentiation between scheduled tribe and scheduled caste. Should we confine it to only Hindus or extend it to other communities also? Because the ultimate idea is to grant benefit to the poor. Now, with that view, therefore, the succession rights also should be changed. Perhaps, in my view, Indian Succession Act, which applies to Christians, under Christian law, says that a widow cannot remarry at all for her life. Today, it is permitted. So, therefore, the share to which a wife gets, children get, etc., as prescribed in the Indian Succession Act, or perhaps requires some modification. Think about it. Then the question of adoption. I had a discussion with my friend on law of adoption. Adopted son under Hindu law to some extent gets a right. He can be treated as a son for limited purpose, property rights. But does it apply to any other law? And will you have an adopted son who is to look after you when you are old? Perhaps with that hope you adopt a son or a daughter. And what is the seniority age? 60 onwards. At that point of time, you look to somebody else to look after you. And will an adopted son look after you if he knows fully well that he is at your mercy for property gifts? This should be therefore some regulation on this aspect. And in some law, adoption is prohibited altogether. When it comes to inheritance, the Mohammedan law says that one cannot will away the property except to the extent of 1/3. But they got a approach there that 1/3 right also is subject to approval by the legal heirs after his death. The word, I lay stress on the word after his death. A man writes a will today, he will not know who will be his heirs. And that will therefore is changed according to acceptance by the heirs. This also requires some modification, clarification, and a person incurs debts, he may transfer the property. The Mohammedan law says that pay up the debts, they have a priority. Should you not also have the same priority linked, except challenging the alienation under section 53A or so, whatever it may be, the TP Act. TP Act is implemented. So these laws require a change, and our fighting on the basis of these laws, which are perhaps inapplicable to the present generation, because the older generation requires protection, maintenance, care. The younger generation can frame the law. So their mode of thinking should be taking into account all the aspects. Now, again in the matter of guardianship, to whom a minor should be entrusted differs according to law, the law by which they are governed. Sometimes maintenance due doesn't get a charge on the property. 125, section 125 doesn't provide a charge on the property, but recovery from the person concerned. Well and good, it's a good law. But so far as liability is concerned, the guardianship also should be taken into account by the concerned judge as to in whose custody the child will be safe. I am pointing out this because for one thing I have found out, today more and more people are employed, whether man or woman, and a domestic life is looked after by a servant. So also child care custody institutions are coming more frequent, because they know that parents are not able to look after the children. And the children do not therefore get a parental love. In these circumstances, should we restrict ourselves to age factor only is the point that I am trying to urge. It is for you to think about it. And divorce, I have already said, should the grounds vary according to each religion, caste, community? No. You should have a uniform system. And incompatibility, as I found, the French law is perhaps more convenient. The judge can give a divorce irrespective of the fact when they are incompatible to pull on the life. For that, one of the reasons why divorce applications or other type of similar applications are made use of in litigation as a means of extracting money from the other spouse. Is there no way where we can stop it? Today, large sums are being claimed from a husband or a wife if they are earning members. And that is made as a weapon to forcibly settle the matter. They are incompatible, no doubt, but at a price. Incompatibility is pressed into ground at a monetary factor or other advantages coerced on the other side. Now with this, therefore, I would submit that multiple system of law prevalent in India should be made uniform, applicable to all, and one should not have uncertainty about which law he is to be guided. I think, exceeding my time already. Thank you for not only listening these ideas, but I want you to put forth your questions and to the concerned persons, because you are all electing a member. Election law says after 18 you can vote, but for marriage, men have to wait till 21 years. At age 18, you are able to discern whether who is a good candidate for you. But for marriage, the man cannot until 21 years, though he is capable of all other things. So, I thank you for affording me to give a talk on the subject, perhaps on which you can go on asking questions. Luminaries are here. They will answer from various points of view. Thank you, sir.
Thank you, sir, for enlightening session by sharing your views on the said topic. Thank you. As a token of love and gratitude, I would request moderator of the program, Dr. B.K. Ravindra, sir, to hand over a memento to Sri M. Ram Mohan Rao. Another guest speaker we have today with us is Dr. Sairam Bhatt. Dr. Sairam Bhatt is a professor of law from National Law School of India, University, Bangalore. His areas of interest are law of contracts, environmental law, constitutional law, energy law, and RTI Act. Professor Bhatt was awarded the Young India Environmental Law Fellowship and is a Fulbright Nehru Fellow 2010. He has held various positions at Georgetown University, Law Center, Washington, D.C. and Royal Institute of Technology, Stockholm. He has authored and edited a variety of publications and also started the National Law School of India University book series, under which he has published a number of books. It's a privilege to have Dr. Sairam Bhatt here with us today as a resource person. He would be addressing the gathering on the topic of need for uniform civil code. Over to you, sir.
ಎಲ್ರಿಗೂ ನಮಸ್ಕಾರ. ಮೋಹನ್ ರಾವ್ ಸರ್ ಮಾತಾಡಾದ್ಮೇಲೆ ನನ್ನಾದ್ಮೇಲೆ ಎರಡು ಲೀಗಲ್ ಐಕಾನ್ಸ್ ಇದ್ದಾರೆ, ಪ್ರೊಫೆಸರ್ ಸನ್ನಿ ಮತ್ತು ಪ್ರೊಫೆಸರ್ ಐತಾಲ್. ನಾನು ಮಧ್ಯದಲ್ಲಿದ್ದೇನೆ. ನಾನು ನನ್ನ ಸ್ಪೀಚನ್ನು ಬಹಳ ಶಾರ್ಟಾಗಿ ಇಡ್ತೇನೆ. ಕ್ವಶನ್ ಆ್ಯಂಡ್ ಆನ್ಸರ್ಸ್ ಇದೆ, ಆವಾಗ ಇನ್ನೂ ಸ್ವಲ್ಪ ಡೀಟೇಲ್ ಆಗಿ ಹೋಗ್ಬೋದು. ಸ್ನೇಹಿತರೆ, ಟೈಟಲ್ ಇರೋದು ಯೂನಿಫಾರ್ಮ್ ಸಿವಿಲ್ ಕೋಡ್. ಇಲ್ಲಿ ಮಾತಾಡಲಿಕ್ಕೆ ಭಾಳ ಖುಷಿ ಆಗ್ತದೆ, ಯಾಕಂದರೆ ಮೆಜಾರಿಟಿ ಆಫ್ ಆಡಿಯನ್ಸು ಯೂನಿಫಾರ್ಮ್ ಹಾಕಿದೆ. ನೀವು ಭಾಳ ಶಿಸ್ತಲ್ಲಿ ಕೂತಿದ್ದೀರಿ, ಸಿವಿಲ್ ಆಗಿ ಕೂತಿದ್ದೀರಿ. ಆ ಕೋಡ್ ಇರೋದು BK ರವೀಂದ್ರ ಮತ್ತು ಅಕ್ಷತಾ ಮೇಡಮ್ ಕೋಡಿಂದ ನೀವು ಭಾಳ ಡಿಸಿಪ್ಲಿನ್ಡ್ ಆಗಿದ್ದೀರಿ. ಸ್ನೇಹಿತರೆ, ನನ್ನ ಸಂಸ್ಥೆಯಲ್ಲಿ ಯೂನಿಫಾರ್ಮ್ ಇಲ್ಲ. BK ರವೀಂದ್ರ ಸರ್ ಎಲ್ರಿಗೂ ಗೊತ್ತು. ಈ ಯೂನಿಫಾರ್ಮ್ ಅನ್ನೋ ಒಂದು ಪದವನ್ನು ಯಾಕೆ ಬೇಕು ಅನ್ನೋದು ಭಾಳ ನಾವು ತಿಳ್ಕೊಬೇಕಾಗತ್ತೆ. ಯೂನಿಫಾರ್ಮ್ ಬೇಕಾ ಬೇಡೋ? ಒನ್ ನೇಷನ್ ಒನ್ ಲಾ ಅಂತ ನಾವು ಹೇಳಿದ್ವಿ. ಓಕೆ, ಬಟ್ ಬಿಫೋರ್ ವಿ ಡೆಲ್ ಅಪಾನ್ ಒನ್ ನೇಷನ್ ಒನ್ ಲಾ, ಲೆಟ್ ಅಸ್ ಫಸ್ಟ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ವೈ do you require one nation one law. But even before that, we should understand that there are two parts to this UCC code or UCC debate. One is the politics of UCC, the other is the legal debate of UCC. We can't merge these two, to be unfortunate. And as lawyers, I think if we can stick to the legal debate, we'll be much wiser. Uniform Civil Code hopes to implement equality and dignity of women. This is the hope of Uniform Civil Code. Women have been denied their dignity, women have been denied their equality. Dignity in marriage, equality in property. Women have been denied. And hence, even Prime Minister Modi, when he said about a certain kind of Muslim women, he said equality and dignity should be the mandate of the Constitution. But having said this, friends, the challenges in law, are men and women treated equally? In practice, are men and women treated equally, or should they be treated equally? ಸಮಸ್ಯೆ ಏನಾಗ್ತದೆ ಅಂದರೆ, see, to be honest, today I was just discussing in the morning, do men and women cricketers get equal pay for equal work? Very recently the BCCI came up with its first rule. ಈ ವರ್ಷ ಅವ್ರು ಏನು ಹೇಳೋದು ಅಂದರೆ, ವುಮೆನ್ ಕ್ರಿಕೆಟರ್ಸ್ಗೂ ಮೆನ್ ಕ್ರಿಕೆಟರ್ಗೂ ಈಕ್ವಲ್ ಪೇ ಕೊಡ್ತೀವಿ. ಫಸ್ಟ್ ಟೈಮ್. ವಿಂಬಲ್ಟನ್ ವಿಮೆನ್ ಟೆನ್ನಿಸ್ ಪ್ಲೇಯರ್ಗೂ ಮೆನ್ ಟೆನ್ನಿಸ್ ಪ್ಲೇಯರ್ಗೂ ಈಕ್ವಲ್ ಕೊಡ್ತೀವಾ ಪ್ರೈಸ್ ಮನಿ? ವಾಲಿಬಾಲ್, ಬಾಸ್ಕೆಟ್ಬಾಲ್ ಈಕ್ವಲ್ ಪೇ ಫಾರ್ ಈಕ್ವಲ್ ವರ್ಕ್ ಕೊಡ್ತೀವಾ? ಅಂದರೆ ಈಕ್ವಾಲಿಟಿ ಅನ್ನೋ ಪ್ರಿನ್ಸಿಪಲ್ಲು ಇಲ್ಲಿ ಎಲ್ಲ ಬೇಕಾಗತ್ತೆ ಅನ್ನೋದು ಐ ಥಿಂಕ್ ನಾವು ಯೋಚನೆ ಮಾಡಬೇಕಾಗತ್ತೆ. ಎರಡನೇದು, when you talk of equality, friends, in an institution called marriage, there have been lot of generations, like Professor Sunny was rightly saying. His generation, the word equality meant differently. Probably the young generation would want to define equality slightly differently. Every generation should have its own say, because, you know, we had our own struggles constitutionally. We had struggles to get civil and political rights initially when the constitution was drafted. Our priority was to get those civil and political rights in the initial stages. That generation fought for civil and political rights. The next generation fought for economic and cultural rights. Maybe this generation has to fight for the right of equality in marriage. Yes, it is a generational fight, no doubt about it. But the point is, friends, the Uniform Civil Code, as we speak about, has its own pros and cons. For example, the Law Commission did say that, okay, Uniform Civil Code can come, but when should it come? Professor Sunny was pointing it out very nicely. When should it come? Which generation should decide that it is required? So I believe that when you talk about the structure of a Uniform Civil Code, friends, because conceptual is fine, but what should be its structure? ನಾನು ಆ ಸ್ಟ್ರಕ್ಚರ್ನ ಒಂದು ಸೋಷಲ್ ಟ್ರಾನ್ಸ್ಫಾರ್ಮೇಷನ್, ಅಂದರೆ ಸೊಸೈಟಿ ಯಾವಾಗಲೂ ಒಂದು ಟ್ರಾನ್ಸ್ಫಾರ್ಮೇಟಿವ್ ಸ್ಟೇಜಲ್ಲಿ ಇರುತ್ತೆ. ಚೇಂಜ್ ಆಗಲೇಬೇಕು ಸೊಸೈಟಿ. ಚೇಂಜ್ ಇಸ್ ದ ಓನ್ಲಿ ಕಾನ್ಸ್ಟೆಂಟ್ ಥಿಂಗ್. ನಾವು ಇಂಪ್ರೂವ್ಮೆಂಟ್ ಮಾಡ್ತಾನೆ ಇರಬೇಕು. ಆ ಇಂಪ್ರೂವ್ಮೆಂಟ್ಗೋಸ್ಕರ ಯೂನಿಫಾರ್ಮ್ ಸಿವಿಲ್ ಕೋಡ್ ಬೇಕು ಅಂತ ನನಗನ್ಸುತ್ತೆ. We should be progressively thinking of a uniform civil code. We must debate it more. But we must debate on the structure. What should be its structure? Let us start with the constitutional principle. Himachal Pradesh government says we have a draft on uniform civil code. I have a problem. I believe that uniform civil code should not be state-wise. Each state should not be allowed to have its own uniform civil code. Let it be a national legislation. So if Himachal does it, tomorrow probably some other state will do it. I don't think we can have a bifurcation of these. Maybe the Himachal Pradesh government can give you a structure of what can be the future of a uniform civil code. Of course, if you research well, the Goa Portuguese code is considered to be a uniform civil code. So you have already one, Goan law that speaks about uniform civil code. ಆದರೆ ಗೋವನ್ ಲಾ ಪರ್ಫೆಕ್ಟ್ ಯೂನಿಫಾರ್ಮ್ ಸಿವಿಲ್ ಕೋಡಾ ಅಂತ ನೀವು ಪ್ರಶ್ನೆ ಮಾಡಬೇಕಾಗುತ್ತೆ. ಯಾಕಂದರೆ ಗೋವಾದಲ್ಲಿ ಹಿಂದೂಸ್ ಕ್ಯಾನ್ ಪ್ರಾಕ್ಟಿಸ್ ಬೈಗಮಿ. ಇಫ್ ಸಪೋಸ್ ದ ವೈಫ್ ಇಸ್ ಅನೇಬಲ್ ಟು ಬೇರ್ ಅ ಚೈಲ್ಡ್ till the age of 25, a Hindu can actually remarry. This is possible in Goa. So Goa code is not also the perfect code, right? But what kind of structure should be there? Of course, we are talking of the different treatment women get. We are talking of how many spouses you can have. We are also sometimes talking about population control as the politics of uniform civil code. But this one nation, one law theory, how important is it? Can as one nation we have one language? ಅದಕ್ಕೆ ನಾನು ಬೈ ಲ್ಯಾಂಗ್ವೇಜ್ ಸ್ಪೀಚ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ. ಸುಮ್ಮನೆ ಇಂಗ್ಲೀಷ್ಲಿ ಮಾತಾಡಿದ್ರೆ ಒಂದೇ ಭಾಷೆ ಮಾತಾಡಿದ್ರು, ಕನ್ನಡದಲ್ಲಿ ಮಾತಾಡಲಿಲ್ಲ ನೋಡಿ. ಕನ್ನಡದಲ್ಲಿ ಪುತ್ತೂರಿಗೆ ಬಂದು ನೀವು ಕನ್ನಡ ಮಾತಾಡಲಿಲ್ಲ. ಹೀಗೆ ನೋಡಿ, ಡೈವರ್ಸಿಟಿ ಇಂಡಿಯಾದಲ್ಲಿ ಅದು ಒಂದು ಸ್ಟ್ರೆಂತಾ ವೀಕ್ನೆಸ್ಸಾ ಅಂತ ನಾವು ಯೋಚನೆ ಮಾಡಬೇಕಾಗ್ತದೆ. ಡೈವರ್ಸಿಟಿ ಆಫ್ ರಿಲಿಜನ್, ಡೈವರ್ಸಿಟಿ ಆಫ್ ಕಲ್ಚರ್, ಇದು ಒಂದು ಡೈವರ್ಸಿಟಿ ನೀವು ಪ್ರೊಟೆಕ್ಟ್ ಮಾಡಬೇಕಾ ಅಂತ ಕೇಳಿ. ಅಥವಾ ಒಂದು ದೇಶ ಒಂದು ಭಾಷೆ ಸಾಕ? ನೀವು ತಮಿಳ್ನಾಡಿಗೆ ಹೋದರೆ ಹಿಂದಿ ಭಾಷೆಯೂ ಬೇಡ ಅವರಿಗೆ. ಸೊ the diversity is a strength. Now how do you protect that diversity within the structure of the uniform civil code? That's very important. We can't lose our diversity, friends. That is an Indian ethos. It's a cultural ethos of this country. Protecting that is this generation's, just don't be having just one language strength. ಹೌದು, ಕೋರ್ಟ್ಸಲ್ಲಿ ಇಂಗ್ಲೀಷ್ ಬೇಕು, ಇಲ್ಲ ಅಂತಲ್ಲ. ಕನ್ನಡ ಇಲ್ಲದೇನೂ ಆಗೋದಿಲ್ಲ. ಸರ್ ಹೇಳ್ತಾರೆ, ಮೋಹನ್ ರಾವ್ ಸರ್, ಲೋಕಲ್ ಕೋರ್ಟ್ಲಿ ಕನ್ನಡವೂ ಬೇಕು. ಹೌದು, ನಾವು ಕಲಿಯೋದೆಲ್ಲ ಇಂಗ್ಲೀಷಲ್ಲೇ, ಯಾಕಂದರೆ ಎಲ್ಲ ಲೀಗಲ್ ಟರ್ಮ್ಸ್ ಇರೋದು ಇಂಗ್ಲೀಷಲ್ಲಿ. ಬಟ್ ಕನ್ನಡಲ್ಲೂ ನಾವು ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡ್ಬೋದು. ಮಾಡೋಕ್ಕಾಗಲ್ಲ ಅಂತ ಏನು ರೂಲೇ ಇಲ್ವಲ್ಲ. ಸೊ ವೈ ಡೋಂಟ್ ವಿ ಥಿಂಕ್ ಅಬೌಟ್ ಅ ಸ್ಟ್ರಕ್ಚರ್ that protects the diversity of this nation as well as gives equality and dignity to women? A balanced approach. And hence, friends, to make a balanced approach, I believe that uniform civil code cannot have a top-down model. Now, when I believe top-down model ಅಂದರೆ ಕಾನೂನು ತಂದು ನೀವೆಲ್ಲ ಚೇಂಜ್ ಆಗಬೇಕು, ಒಂದೇ ಕಾನೂನು ಅಡಿಯಲ್ಲಿ ಬರಬೇಕು ಅನ್ನೋ ಒಂದು ದೃಷ್ಟಿ ಬರಲಿಕ್ಕೆ ಕಷ್ಟ ಇದೆ ನಮ್ಮ ದೇಶದಲ್ಲಿ. ಯಾಕಂದರೆ ಟು ಬಿ ಆನೆಸ್ಟ್, ನೀವು ದೇಶ ತಿರುಗಿದ್ರೆ ಈ ದೇಶ ಏನು ಅಂತ ನಿಮಗೆ ಅರ್ಥ ಆಗ್ತದೆ. ನಾರ್ತ್ ಈಸ್ಟಿಗೆ ಹೋಗಿ, ಜಮ್ಮುಗೆ ಹೋಗಿ, ಯು ಪಿಗೆ ಹೋಗಿ, ಗೋವಾಗೆ ಹೋಗಿ, ದಮನ್ ದಿವ್ಗೆ ಹೋಗಿ, ಈ ದೇಶ ಇಷ್ಟು ವೈಡ್ ಇದೆ, ಇಷ್ಟು ಡೈವರ್ಸ್ ಇದೆ. ಆ ಎಲ್ಲವನ್ನೂ ನೀವು ಯೂನಿಫಾರ್ಮ್ ಸಿವಿಲ್ ಕೋಡ್ಲಿ ಹೀಗೆ ಕ್ಯಾಪ್ಚರ್ ಮಾಡ್ಬೋದು. ಇಷ್ಟು ವರ್ಷ ಅದನ್ನು ಡಿಲೇ ಮಾಡಲಿಕ್ಕೆ ಏನು ಕಾರಣ ಇತ್ತು ಅಂತ ನಾವು ಫಸ್ಟ್ ಅರ್ಥ ಮಾಡ್ಕೋಬೇಕಾಗುತ್ತೆ. ಆ ಡೈವರ್ಸಿಟಿನ ಇರೇಸ್ ಮಾಡಿಬಿಟ್ಟು ಒಂದೇ ಕೋಡ್ ತರೋದ್ರಲ್ಲಿ ಮೀನಿಂಗ್ ಇಲ್ಲ ಅಂತ ನನ್ನ ಅಭಿಪ್ರಾಯ. ಸೊ ಫ್ರೆಂಡ್ಸ್, ಐ ಹ್ಯಾವ್ ಅ ಪ್ರಪೋಸಲ್ ಬಿಫೋರ್ ದಿಸ್ ಆಡಿಯನ್ಸ್, ಆ್ಯಂಡ್ ದಟ್ ಪ್ರಪೋಸಲ್ ಇಸ್, ಐ ವಾಂಟ್ ಟು ಇಂಟ್ರೊಡ್ಯೂಸ್ ಯೂನಿಫಾರ್ಮ್ ಸಿವಿಲ್ ಕೋಡ್ ಇನ್ ದ ಕರೆಂಟ್ ಸ್ಟೇಟಸ್ ಆಸ್ ಇಟ್ ಈಸ್, ಆಸ್ ಅ ಚಾಯ್ಸ್ ಬೇಸ್ಡ್ ಸಿಸ್ಟಮ್. This is a proposal. You can criticize me. You are free to do that. Choice-based approach instead of a top-down approach. Top-down approach alli we want the society to change overnight. It's a parliament law. Uniform civil code should apply from today. But I want a choice-based approach. You know what is a choice-based approach? Is because today's current generation is more and more getting into interfaith and intercaste marriages. Yes or no? ನೋಡಿ ಎಲ್ಲ ಎಸ್ಸೇ ಹೇಳೋದು ಮಾಡಬೇಡಿ ಹಾಗೆ ಮಾಡ್ಬೋದು. Point is, where there is intercaste and interfaith marriages, please note we already have a legislation called the Special Marriage Act. You have a Special Marriage Act, right? I'm sure as family law you will be dealing with the Special Marriage Law. My proposal, and please note that proposal that Professor B.K. Ravindra would want to send it to the Law Commission of India, is that this Special Marriage Law should be converted into a uniform civil code. It should include maintenance, inheritance, succession, adoption and divorce as well. Already divorce is there. But before Special Marriage Act can be the tool for the Uniform Civil Code, there are two things in Special Marriage Act that need to be changed. If you are talking of equality and dignity, we must remove restitution of conjugal rights from Special Marriage Law. I'm sure every woman in this auditorium who knows what restitution of conjugal right means will agree with me. So Special Marriage Law has to be amended and revised, first of all. And then there should be a addition of adoption, inheritance and succession into this law, so that it becomes a choice-based uniform civil code. So if a couple wants to get their marriage registered, and marriage registration should be compulsory, they can then go under the Special Marriage Act, and every other part of marriage will be decided under that law. Be it property, be it children, be it any other rights that may come from marriage. So you give the current generation a choice. Do you want to stay in your religion, or do you want to come under a uniform civil code? Give them a choice. The fact of a choice-based system, friends, I'm sure even the Bar Council says choice-based system na introduce ಮಾಡಿ ಕೋರ್ಸಸ್ ನ ಫೋರ್ಸ್ ಮಾಡಬೇಡಿ ಸ್ಟೂಡೆಂಟ್ಸ್ ಮೇಲೆ, ಅವರು ಚೂಸ್ ಮಾಡ್ಕೊಳ್ಳಿ, ಇಂಟರ್ನ್ಯಾಷನಲ್ ಲಾ ಬೇಕಾ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ ಲಾ. ಎನಿವೆ ದ ಪಾಯಿಂಟ್ ಇಸ್ ದ ಕರೆಂಟ್ ಜನರೇಷನ್ ಲೈಕ್ಸ್ ಫ್ರೀಡಮ್ ಆಫ್ ಚಾಯ್ಸ್. ಎಸ್ ಆರ್ ನೋ? ಅಟ್ಲೀಸ್ಟ್ ನೀವು ಎಲ್ಲ ನಾನು ಹೇಳ್ದೆ ಹ್ಞೂ ಅಂತ ಹೇಳಬೇಕು. ಚಾಯ್ಸ್ ಬೇಕಾ ನಿಮಗೆ? ಇಲ್ವಾ? ಮೇಲ್ಗಡೆಯಿಂದನೇ ಬೇಕಾ? ಕೋಲಿಂದ? ಸೊ ದ ಪಾಯಿಂಟ್ ಇಸ್, ಐ ಬಿಲೀವ್ ದ ಚಾಯ್ಸ್ ಬೇಸ್ಡ್ ಸಿಸ್ಟಮ್ ಕ್ಯಾನ್ ವರ್ಕ್. Now, please note, in our proposal that we are making, we are saying that this Special Marriage Law should not only be prospective, it must be retrospective. ಇದು ಒಂದು ಸ್ವಲ್ಪ ಕಾಂಟ್ರವರ್ಷಿಯಲ್ ಗೂಗ್ಲಿ ಹಾಕಿದ್ದೇನೆ. 1990 ಆದಮೇಲೆ ಮದುವೆ ಆದವರು ನಮ್ಮ ದೇಶದಲ್ಲಿ ನಿಮಗೆ ವಿಮೆನಿಗೆ ಈಕ್ವಲ್ ಸ್ಥಾನ ಕೊಡಬೇಕು, ರೈಟ್ಸ್ ಕೊಡಬೇಕು, ಪ್ರೊಟೆಕ್ಷನ್ ಮಾಡಬೇಕು ಅಂದರೆ ಯಾರೇ ಒಬ್ಬ ಇಂಡಿಯನ್ನು ಅಥವಾ ಇಂಡಿಯನ್ ಕಪಲ್ಲು 1990 ಮದುವೆ ಆದಮೇಲೆ ಒಂದು ಡೇಟ್ ಒಂದು ಫಿಕ್ಸ್ ಮಾಡಿದ್ದೇನೆ, ಯಾಕೆ ಅಂತ ಕೇಳಬೇಡಿ, ಸುಮ್ಮನೆ ನಿನ್ನೆ ರಾತ್ರಿ ನೆನಪು ಬಂತು 1990 ಬೆಸ್ಟ್ ಅಂತ. ಆಫ್ಟರ್ ದ್ಯಾಟ್ ದೇ ಕ್ಯಾನ್ ಆ್ಯಕ್ಚುಲಿ ಶಿಫ್ಟ್ ದೇರ್ ಮ್ಯಾರೇಜ್ ಇನ್ ಟು ದ ಯೂನಿಫಾರ್ಮ್ ಸಿವಿಲ್ ಕೋಡ್, ಇನ್ ಟು ದ ಸ್ಪೆಷಲ್ ಮ್ಯಾರೇಜ್ ಆ್ಯಕ್ಟ್, ಆ್ಯಂಡ್ ಹೆನ್ಸ್ thereby women will get not only the right to maintenance but also equal rights in the property which is called matrimonial property. So if we are talking about dignity of women, friends, let's also talk about the dignity of choice of women. Let women choose, because friends, my basic problem is, so far as per the Supreme Court decision, Professor Aital will tell you more about it, but the Supreme Court has said something like this: there is something called essential religious practice rule, like the constitutional morality rule. The Supreme Court now has come with the essential religious practice rule. I don't know if you have read the Sabrimala judgment, you will understand what I am speaking about. The basic problem is marriage an essential religious practice? How many of you have the guts to answer this question? If it is so, then any top-down law of the parliament will be struck as unconstitutional, because it will infringe the right of religion and religious rights under Article 25-26 of the Constitution of India. I believe marriage is not an essential religious practice. Marriage ceremony is. The procedure for getting married is religious practice, but marriage is not. We have to make a distinction, and we have to be able to defend it before the Supreme Court of India. So, to take away marriage from religion, the best is to give people a choice. I think we must segregate religion from so many other systems of the society. It is time that this current generation makes that choice. Don't mix up religion with so many other things of our society. You pray, it's your faith. You want a pujari to witness your marriage, it's your faith. You want the pujari to say Ashirvada, do well and give you some sermon, it is your faith. But a union between man and a woman is not. Right? That is for the state to determine. However, friends, quickly summing up my so-called proposition before this audience, because Professor Ravindra said we must give some proposals. I must tell you that in my proposal there is a defect with this current generation should solve. And that defect is, because I have to tell you the advantages of my proposal, also tell you the disadvantages. No? So one of the disadvantages of my proposal is that under the special marriage law, we'll have to define whether marriage is a union of a man and a woman only. Those who are intelligent understood. Those who are not are wondering. Because Menaka Guru Swami, arguing the Supreme Court of India on same-sex marriages, has said, I want recognition under the Special Marriage Act. So the point is, while special marriage law can be important, please note, current generation has other rights that they want to be recognized under the Constitution. And you cannot forget those rights when you're talking of the rights of the Uniform Civil Code. LGBTQ. And please note, one of the drafts that is in circulation, you can Google it, actually says that the definition of marriage under Uniform Civil Code will be the most important definition for us to resolve. And that is how probably I think we should work on making a draft, creating a structure, and based on that structure, I'm sure insights and inputs can be got from informed citizens. And I'm sure as a progressive nation, let's always welcome change. Let's always work towards educating women, empowering them through education and saying, look, there is a better choice for protecting your rights, exercise that choice and come under the Uniform Civil Law. It will actually be not only good for you, but it will be good for your generations to come as well. And that, I think, should go in a long way in bringing a social transformation in our country. Thank you very much.
Thank you, sir, for bringing us today a very productive session. As a token of love and gratitude, I would request moderator of the program, Dr. B.K. Ravindra, sir, to hand over a token of gratitude to Dr. Sairam Bhatt. The next eminent speaker we have with us today is Dr. K.R. Aital, Professor of Law, Presidency University, Bangalore, and former Dean Faculty of Law, Karnataka University, Dharwad. Dr. K.R. Aital served in Karnataka University, Dharwad for a period of 28 years in various capacities, including acting Vice Chancellor for a brief period. During his legal academic career of nearly 3.5 decades, made substantial contribution to the field of legal education and research. He has authored one book and published more than 27 research articles in national and international law journals and legal periodicals, and successfully guided 11 PhD candidates, and many of them have excelled in their career. Dr. K.R. Aital is a legal scholar and academician with over 33 years of teaching and research experience in the field of law. After retirement from university service, He took up academic assignment with the sole objective of improving the quality of legal education and research. We are much privileged to have you here to speak on the topic judicial decisions and judgments of the court. Over to you, sir.
Distinguished jurists on the dais, legal scholars, students, ladies and gentlemen. In fact, I was asked to speak about the Supreme Court on Uniform Civil Code. In fact, you are all aware of that India has never ruled by a single system of law throughout history. Even today, majority of the scholars in Western world, they don't want to call India a nation. It is a subcontinent consisting of several nationalities, and therefore that. So the one attempt by virtue of which we wanted to promote national integration and social cohesion is through this Uniform Civil Code. Often it come to the forefront of political, legal discourse, but again it goes to the black burner. So in fact, before, immediately after the advent of Muslim invasion, that Muslim never recognized Indian law or legal system. Only when it is in fact useful, it has been recognized. Of course, there was separate laws since Muslim invasion. Of course, earlier also we were not ruled by something called a law that is applicable to all, because that even before Muslim invention, the laws were based on customs, traditions, and all sorts of things which we consider now to be discriminatory and unjust. Anyhow, that in fact, that Britishers, they started, of course, that, so they wanted to, in fact, certain laws, because it was chaos in what law should be applied in presidency towns and what law should govern Christians, because that Britishers not only want to rule the country but also want to their religious conversion as a part of that is even Constituent Assembly also considered that the conversion is an essential aspect of both Christianity and Islam. So that is why that then the problem has come up whether we should apply to these converts, whether Christian law or Hindu law or the local customs, usages, etc. So that is how this problem of that Britishers were facing, and that is why the first law commission in 1933 so was constituted. In fact, that Lord Macaulay so was the in fact one of the members, and so the other directors of the East India Company constituted first law commission, and there the issue of course, in fact in Western society the law has been divided into three categories. One is civil, criminal, and personal laws. They were largely based on, even in Western society, on religious prescriptions or canon law. So it was only in 1883. So in England, in fact, that so the separate religious law relating to marriage, conversion, inheritance, etc. was abolished, and House of Lords jurisdiction was unified. Until then, so the in fact civil status, the law, civil code is normally concerned with, Uniform Civil Code is concerned with civil law. In fact, in Christian law, so the civil status is determined by, in fact, all European laws. So after abolition of canon law based on status, and in fact Muslim law, they consider it not based on status but based on contract. So in spite of the of course Hindu law is based on so the ancient prescription, where that is why that Hindu marriage, so the divorce was not recognized at all, because the relationship continues for 7 incarnations, whereas in Muslim law so that it is a civil contract, whereas in Christian law it is based on civil status. That means that one generation. In fact, this monogamy was started with the prescription in 10 commandments. What is that? 7th commandment. Thou shall not commit adultery. That was the basis of monogamy. And then, there was, of course, one thing has happened after introduction of printing industry, printer's devil. Why it has come? Printer's devil. So in 200 million copies of New Testament Bible, the 7th command, thou shall not commit adultery, has become, thou shall commit adultery. Print mistake. That is why the printer's devil. So anyhow, in fact, personal laws governing relationship in the society. So there were these 3 types we have. And therefore, after in fact British rule, so when the Western civilization is mingled with Indian civilization, whereas India was not at all ruled by a single ruler, and this subcontinent is, in fact, the present India is the largest portion, it is independent India, is ruled by a single government. That is why we have to accommodate, that in our laws, diversity. So the problem, that is why first law commission, which was asked to produce codes, Benthamite experience, that. So England did not accept Bentham's codification project, but Britishers, they try to introduce into India, because we have so many diverse laws, and somehow we can ensure some sort of uniformity and to make the law more comprehensible. So this first law commission was constituted. Of course, they recommended for the codification of all laws, and first law commission drafted Indian Penal Code in 1937. Of course, it was brought into force only in 1860. So the 1837 it was drafted. So then, of course, that as far as civil law is for what about others? That is why the Law Commission recommended for the, in fact, extension of British law, and given an option to both Hindus and Muslims to opt for British law. That is how that English law was introduced. And then, in fact, since then, 1937, so this Uniform Civil Code controversy or the issue continues. And in fact, that in Constituent Assembly there was a very heated debate and about, in fact, the drafting committee wanted there should be Uniform Civil Code provision should be part of fundamental rights. Most of the Hindu, only 6 women members of the Constituent Assembly, they vociferously argued for inclusion of a provision for Uniform Civil Code in Part 3 of the Constitution as a part of fundamental rights, so that immediately after independence, that it must become a part of the legal system. Whereas 5 Muslim members, in fact, that, so the consistently opposed on several grounds. In fact, I wanted to quote 1 or 2. Why because that most of our decisions after the independence are based on this Constituent Assembly debates, wherein in fact that so in Constituent Assembly, so the member Poker said that there should be an exception to the draft article 35, which provides that there shall be So the Constituent Assembly introduced, the state shall endeavour to secure for the citizens a uniform civil code throughout the territory of India, and all 5 Muslim members proposed amendments. So 2 amendments I will read. One is, provided that any group, section or community of people shall not be obliged to give up its own personal laws in case it has one. That is what Muhammad Poker introduced, and another Ismail Beg. So he introduced an amendment, provided nothing in this article shall affect the personal law of the citizens. In fact, there is nothing like personal law. It was a phrase introduced by the first law commission. In fact, civil relations, in fact, that for the purpose of postponing implementation of uniform civil code, that so the 21st law commission, instead of personal law, they emphasize on the phrase family law. So in fact, that is why ultimately, of course, Dr. B.R. Ambedkar, so it was intended to be introduced in part 3, but it was subsequently included in part 4 of the Constitution, the same that without considering or accepting any of these amendments proposed by particularly minority members. So then, in fact, that they are left it open, and then, of course, Constituent Assembly people have agreed for that amendment. The passing of and inclusion of the provision regarding Uniform Civil Code in Part 4 of the Constitution. And immediately after that, Part 4, that it was thrown to dustbin, because it is not enforceable. Of course, there is nothing like, only those rules that are enforceable by a court of law must be considered as part of constitutional law. But directive principles, of course, Supreme Court in the name of judicial activism is now enforcing several provisions of the directive principle. That is why, that after, these elections, that BJP brought this to the forefront. Because Supreme Court, that is why several public interest litigations have been filed, requesting or asking the court to pass an order directing the parliament to make a law implementing Uniform Civil Code. So the attempt was made first in 1951 itself in one Bombay case, State of Bombay versus that case. In that State of Bombay versus, where is that? So where the issue was 1946, Prohibition of Bigamous Marriage Act, where the Bombay High Court held that, in fact, that because there is no Uniform Civil Code, but in 1946, Bombay Province enacted a law under Section 5 and 6 of the Bombay Prohibition of Bigamous Marriage Act. So if a person contracts another marriage during the life of the wife, is guilty of an offence punishable by 6 months imprisonment and fine. So it was challenged before the High Court. So the one magistrate prosecuted and punished the defendant in that particular case. And of course, from 1951 to 1985, the issue was dormant and no case was filed. It was only in 1985, Shabano case, it was revised because in 1932, Shabano was married in 1932. That to an advocate. He was having a very good practice. And in fact, she was thrown out in 1975 from the matrimonial home unceremoniously and cruelly. So she sought maintenance under section 125 of CRPC. As of course you must have studied. So then in fact she was given, of course under Muslim law, so the divorce is given, so dowry has to be repaid, and rupees 20 maintenance was granted by the court to her in 1975. And in 1977 she went to Supreme Court, and that case through the High Court, and High Court enhanced the maintenance by 179 rupees, and the Supreme Court in fact upheld High Court in 1985. Savanoor case, the issue was whether a Muslim divorced woman can claim maintenance under section 120 FI of CRPC. Of course, this has raised a very good issue. In fact, can the minorities refuse to obey the law, in fact, secular law, in the name of personal laws? In fact, that since 1921 to 1985, in fact, the Justice Y.V. Chandrachud, father of present Chief Justice, held that she is entitled to maintenance under section 125, and also awarded in fact the 10,000 rupees by way of litigation costs. So then the issue is, in fact, vociferously, in fact, Muslim patriarchy has opposed. And then in fact, that Rajiv Gandhi, succumbing to the pressures of Muslim, in fact, patriarchy, so the nullified the decision to a greater extent, nullified the decision of the Savanoor case, and held that Muslim women are not entitled to maintenance from the husband, but from the ancestral property, her father's property, she is entitled to get maintenance. That is how that 1986 Muslim Women Maintenance Act. Then the issue is, how many women have property, ancestral property? So who should maintain? Then the provision has been made whereby that Waqf board has to maintain under that 1986 law. So then of course because that most of these personal laws are based on religious prescriptions, tribal customs and usages. So they are naturally in conflict with modern notions of justice and equality. So far no society is able to establish an acceptable standard of justice and equality. So that is why some people will argue there is nothing like equality, because two human beings are equal in all respects. Therefore, equality is a tautological concept. It is not a real concept. However, in fact, that people are equal in certain respects. They are different in certain other respects. That is why, that one basic tenet of your feminist jurisprudence is when men and women should be considered equal, when they should be considered different. This is the fundamental issue of every legal system, and that no system has able to arrive at a uniform standard by virtue of which that. So under these circumstances we can treat men and women equally. That is why that these feminists, they argue that men and women can be equal only if the women can act as men. So many people cannot. That is why that protective discrimination, your reservations, etc. So anyhow, the issue is, so in Savanoor case, so the 3-judge bench said that Muslim women are entitled to maintenance under section 125 of CRPC, because that it is a universal law. So Muslims have accepted that criminal law, codification of criminal law. Can we impose Sharia criminal law into India? If we implement what will happen? If they say that marriage law should not be, that is our religious law they wanted. But if the criminal law and if in fact even in Saudi Arabia, even today corporeal punishment is there. So the public beating, hanging, everything is there. That is why for that they have accepted. In the beginning itself. Only certain aspects, of course, that is one problem with diversity. And the political system, our political managers have not succeeded in properly managing the diversity of Indian society. That is the problem. Center of the problem lies here. So so thereafter what happened was another case, that triple talaq case. When the Muslim marriage is a civil contract, how can it be terminated only by the husband by pronouncing talaq 3 times? Unless it is incorporated in a contract, or if some law superior to an agreement is there, then of course that triple talaq can be legally valid. So once we start with the idea that marriage is a civil contract, so just like in fact how can that one party invalidate the marriage and give divorce? By pronouncing 3 times. Only husband has, no wife. No wives can give talaq pronouncing 3 times, is it not? That is why it is discrimination. Shayara Bano case, the Supreme Court in 1978 held. So 2002 or so, held that the triple talaq is unconstitutional and invalid. So that is why, in fact, there is a conflict between, in fact, the Shabano case and this case. That is why, that a larger bench was constituted by the time a temple entry case came up, and in fact, an argument was advanced in Shaira Banu case, where, of course, 3 judges held that triple talaq unconstitutional, whereas other 2 judges, Abdul Nazir and Chief Justice Kehar. So they said that it is in fact based on Muslim law, and that is based on the section 25. It is based on religion, and Article 25 of the Constitution. So the guarantees freedom of religion. So the freedom to practice religion, and accordingly, in fact, it is one of the essential practice of Islam. Of course, there is a controversy surrounding whether all Muslims are governed by Islam. That is also a doubtful proposition. It is still there. There are some people try to distinguish. In fact, law is Islamic law. Sharia law is based on Islamic. Quran is Islamic, not Muslim. That is also an argument is there, that is going on. All religious, of course, prescriptions will become, of course, controversial for one or the other reasons. Anyhow, that is why a larger bench was constituted to determine the relationship between your religious-based personal laws and the Article 25 of the Constitution. So that is why. That is how that Supreme Court has to determine, and accordingly, in fact, by the time, what is that? Another case came, temple entry case, that Shabarimala. So where, in fact, that whether it is this practice of preventing some women, the menstruating women from entering into Shabarimala temple, whether it is a part of essential practice of religion. So that is how a 7-bench judgment was, in fact, was constituted. Even now it is in 9-bench judge. The relationship between personal laws and the Article 25 and 26. Because of the temple entry case, Article 26 also came to the forefront. The relationship, not only, in fact, 25 and 26, in fact, that Hindu, who is that Hindu Malhotra, in that case, temple entry case held that, the Article 26 cannot be attracted because it is subject to public order, morality, and not subject to other provisions of the Constitution. So whereas Article 25 is subject to other provisions of the Constitution, that is why a relationship can be built between Article 14, 15, 16 and other parts and this triple talaq. So the challenge was violation of equality, Article 14 and 15. So then it was negatived because you know that Article 26 is not subject to other provisions, independent article, and it can be regulated only on the three grounds: health, public order, morality. So in that way, so the 9 bench was constituted, and 21st this law commission was constituted to draft a uniform civil code, and so that committee submitted a report, and I will wind up by reading. So if you read the report of 21st Law Commission, you know that's full of inconsistencies will be there. At one point of time they say one thing, and at another point. So I will conclude it by reading what this Law Commission has said in regarding implementation of in the absence of any consensus on the Uniform Civil Code, the Commission felt that the best way forward may be to preserve the diversity of personal laws, but at the same time ensure personal law do not contradict with fundamental rights. So that is why any implementation, of course, you know that, now the issue is everything on Uniform Civil Code depends upon consensus in the society. In fact, it could have been easily built up at the time of independence, but over a period of 75 years, as told by other resource persons here only, in fact, the change of 70 years, the people's preferences, etc. will change, and now that consensus has been shattered. So the consensus has to be rebuilt. Can it be rebuilt by who? Who should build? So it is the political process, and other than legal process can build a consensus. So can our political process be able to build such a consensus? That is the issue. Unless there is a consensus on a uniform civil code, these are the uniform civil code in the society and in the polity. So it cannot be easily implemented. So with this, I would like to thank the organizers for giving me the opportunity to speak about the Uniform Civil Code. I thank you for all of you for giving a patient hearing. Thank you very much.
Thank you, sir, for giving such an informative and comprehensive presentation. As a token of love and gratitude, I would request moderator of today's technical session, Dr. B.K. Ravindra sir, to hand over a memento to Dr. K.R. Aital. The next eminent speaker we have with us today is Dr. K.C. Sunny, Professor and Dean, Central University of Kerala. He holds a PhD in law from University of Kerala and training certificate in international humanitarian law from the Institute of International Humanitarian Law, Geneva. He was the Vice Chancellor of National University of Advanced Legal Studies, Kochi for 4 years. He was the International Observer to Nepal Constituent Assembly Election 2006 and Bangladesh Parliament Election 2007. Served as the Program Chair of the International Conferences on Law and Public Policy held at Singapore for 7 years. 17 researchers, including 2 foreign candidates, did PhD under his supervision. He has served as the member of various academic and administrative bodies and was also the member of various government committees, UGC expert committees and NACP team. He was the chairman of the committee of the Kerala government for suggesting amendments to various laws for ensuring ease of doing business. Dr. Sunny has authored several research papers, articles and books on various topics such as constitutional law, human rights and legal education. I invite Dr. K.C. Sunny to speak on the topic religious rights and freedom vis-a-vis Uniform Civil Code. Over to you, sir.
Respected Chair and eminent scholars present on the dais and dear students. I will take only 10 minutes. Actually, I had 3 options. According to the schedule, my time of presentation is 12:15 to 12:35 and I have 20 minutes. My first option is to say that my presentation may end at 12:35. No, now this is 12:55. Then everybody except Professor Ravindra will be happy if I exercise my first option. The second option is that I can take my 20 minutes and invite the cults of younger generation present here. That is the second option. Third option is one via media approach. Regarding this issue, my humble submission is that government and all the stakeholders in relation to Uniform Civil Code may take via media approach. Whether it may implement immediately or now we passed 70 years after the enactment of the Constitution, whether we wait for another 70 years. Definitely, Uniform Civil Code may be implemented. Before implementing it, every stakeholders may be convinced regarding the need of the implementation of the Civil Code. We can take maximum 2 years. That is all. That is my personal point of view. Then coming to my topic, religious rights and freedom vis-a-vis Uniform Civil Code. When we are discussing about the rights of the religion, I think discussion may be confined to rights guaranteed by Constitution. This is Vivekananda Law College. There is a classic statement by Vivekananda, great Vivekananda, regarding religion. There are 3 things related to religion. First thing, mythology. May be very good for TV serial and documentary and cinema. Second one, basic philosophy of the religion. Third one, any religion. Third one, ceremonies and rituals. Coming to these 2 things and rights guaranteed by the Constitution in relation to religion, without a hesitation I can say that no provision of law existing in this country is against any religion. Maybe against mythology of the religion, maybe against some ceremonies and rituals of the religion. Then, when we speak of, then coming to the provisions of the Constitution, there are 2 or 3 provisions in the Constitution, but as far as individual is concerned, only Article 25. That is, right to profess, practice and propagate religion. Though almost all other fundamental rights are guaranteed in absolute terms, purely absolute, or provision with certain clauses like state may impose reasonable restrictions or procedure established by law, etc., etc. This provision is only a limited provision, religious right, subject to public order, health and morality. That is very important. Subject to public order, health and morality. We have only right to propose, practice and propagate religion. Then regarding this provision, there are so many judicial decisions. And if you go through the decisions related to Tandava, including decisions related to Tandava dance, then this so many decisions in relation to the Shabani issue, all these things. I think right to propose, practice and propagate religion is not violative of any of the provisions of the law existing in this country. Then we may go to the broad perspective. Human beings originated in Congo Basin nearly 50 to 70 lakhs years back. Human beings originated in Congo Basin. That is anthropology. This civilization has only the history of less than 20,000 years, including all civilizations have the history of only 20,000 years. Then this religion is the part of emergence of civilization. All religions are as part of the civilization. Then we cannot predict the history of Hindu religion. But coming to Christian religion, we can predict. Because it is only after Jesus Christ. Only 2,000 years history, maximum. Islam has less than, I think, only 1,400 years history. Vedic period. And this Vedic values, it has only less than 20,000 years history. In this context, we may analyze the thing. First thing. But for making the man to have an orderly life, the most important contribution is by religions. Because what is the fundamental difference between human being and an animal? The life of the animal is confined with a limited aim: eating, sleeping and reproduction. Eating, sleeping and reproduction. But coming to human beings, there are so many values, so many priorities, so many permutations and combinations, for the life of the human being. To make human being an orderly life, the contribution of religion is very, very substantial. One of the reasons for this religious practices is to make an orderly life. Brahman should do these things. This guy should do these things. Christian should go to church or observe Sabbath. Muslim should niska. The ultimate aim of all these practices is to make an orderly life. That aspect may be in our mind. Then, coming to human beings, when I am teaching human rights, Dr. Sairam is also a teacher of human rights. I will say, human beings may be treated as the worst element in this world. Because it is only human beings who are taking food, even if he or she does not feel hunger. Other animals will take only food at the time when they feel hunger. Then, coming to this desire for sex, for other animals it is seasonal. For human beings, at least for one section, 24 hours and 365 days. That is a position. So, for controlling human beings and to make an orderly life for human beings, very, very difficult task. Actually, this task was performed by religion. That is a reason for the civilization also. Even Karl Marx acknowledges this fact. Now what is the position? There are so many avenues. For having an orderly life, we can adopt different strategies. Because in national law schools, we may motivate the students for the purpose of maintaining discipline. I think about what may be the strategy. Finally, some students say that, sir, you may say that, for getting, if this type of conduct is followed, you may not get campus placement. You may not get that may be the strategy. So, my point is that perception of generations may change. We have new generations with a new perspective. That point is rightly raised by Sai Ramphut. Then, in this situation, different generations are leaving. I said at least 5 generations are in our state. If we take 20 years as the period of 20 years as one generation. So, we have to take into account of the claims and interest and value judgment of all generation. That is one point. Then coming to law reform. Actually, there are so many secular enactments. Coming under this family law, what about Domestic Violence Act? I am from Kottayam district basically. In that Kottayam district, generally there is a famous cinema dialogue also. If females say or object or argue, we will blow them. That was the attitude for centuries. But after the enactment of this Prevention of Domestic Violence Act, everybody forced to accept the values of that accept the values enshrined in this Domestic Violence Act. Now, legislation relating to aged parents, new secular legislation, such a type of reformation is necessary at one level, including same age of marriage for male and female. Then we can think about uniform civil code. Then, especially in relation to capacity for marriage, grounds for divorce, basic standards for inheritance, then basic standards for adoption, etc. But after fixing these standards, that may be published. Then new ideas like this concept of matrimonial property, etc. may also be published. That is my general point of view. I think now I crossed 10 minutes. I am stopping here. I express my sincere thanks again to Dr. Ravindra for inviting me. Thank you very much.
Thank you, sir, for sharing your knowledge and information on the said topic. As a token of love and gratitude, I would request moderator of today's technical session, Dr. B.K. Ravindra, sir, to hand over the memento to Dr. K.C. Sunny. Uniform Civil Code is a topic that needs discussion. Keeping this in mind, Vivekananda Law College took the initiative to organize this national seminar, and in order to elicit public opinion, both for and against, from all the sections of the society. We created Google Forms and circulated through our social media networks, and we got good responses from both general public and the student community. So on behalf of them, I present some of their questions on the, to the scholars on the stage and request them to clear the doubts. So each resource person will be kindly asked a couple of questions. Please do answer this. Thank you. So I humbly request Sri Ramohan Rao sir to address on the question. The question is asked by Nalini of 5th BA LLB. The question is, if Uniform Civil Code implemented successfully, how will it affect on legal system?
It's a very problematic question. Our legal system will follow the uniform law, that's all. Where is the difficulty in following a lawyer's profession, in enforcing a code which is applicable to all? But the problem comes, opting for a marriage under the special enactment or limiting marriage under the Uniform Civil Code for a particular number of years only may result in problems later if some don't opt for it or a continuation of it. I don't see any problem in practicing law and applying the Uniform Civil Code.
Okay, there is a question from general public. Whether the special provision given for the tribal people in India can be affected by the Uniform Civil Code. That is from Suresh Puttur. And regarding the same topic, if there is one more question with regard to the same. If the Uniform Civil Code is implemented, will it protect the cultural practice of tribal community? This question is asked by Ashok from Mangalore.
The rights of the tribals are assured to be protected when they wanted to merge with India at the time of independence. It is not as if they have been given a guarantee of that practice which is averse to general law or common notions of morality and the items covered by schedule, 7th schedule and item 3. There is no harm because when our fundamental right is equality, equal law amongst equals should not mean that inequality is made into equality. So I don't think there will be any harm in enforcing a common civil code, even for tribal people. Otherwise, what I have already said, ST, SC categorization, both are Hindus, but why discrimination? So, to save that right, can you enforce a separate law, is the point.
There is a question from Syed Hussain from Bangalore. What is your comment on triple talaq? What is your comment on triple talaq?
I am against the very word talaq itself because by giving reasons, if you can divorce a wife, why not go to court and get a good reason? So on talaq, my opinion is simple. It is given to the husband only. What about wife? When equality of law you propagate, that law should not be there. And I think common civil code can regulate it by saying that anybody wanting a talaq, go to court and ask for talaq on that ground. Specify what are the grounds so that the other side will know what exactly it is. It is one-sided. That's what I do not like to be implemented.
Okay, there's a question from Abhishek Lal from 5th BLLB. This is the last question for you, sir. So, whether Uniform Civil Code rule will contravene the secular principle of country which is enumerated in our constitution?
Secularity should not let down integrity as one nation. Where divisive forces are trying to attack the nation itself, I call it as an enemy within. That we should prevent. Enemy from outside we are defending already well. On all our borders we have got the army defending us, the navy and others defending us. But if internal forces want to divide the law, the region, divide the enforceability of a law on the ground that we are different from others, it is inequality, nothing else. Based on religion and other things, don't try to divide the nation on any ground. Especially when we have achieved so much in the last 70 years. Why try to still enforce that and say that we are different from others within the country?
Thank you, sir. So I kindly request Dr. Sairam Bhatt, sir, to address on the questions to the audience. The question is from Dinesh Bhatt Puttur. If Uniform Civil Code is applicable, what will be the status of marriage system, property of transfer system and religious right?
No, religious rights are not to be merged with the need for a uniform civil code. Yes, property system, yes. I think, if someone goes by property law or tries to redefine property law in India, we say that property can be private property, we can be talking of government property, we can be talking of common property, that's all. But unfortunately, the litigation on property, I'm sure Mohan Rao sir will tell you, largely is based on property, based on inheritance and succession. So I think the Uniform Civil Code actually, if it brings about clarity on property rights, on inheritance and succession, it will reduce the pendency of so many cases in the courts. So I think it is very much required, and it's, I think, the need of the hour. Because finally, friends, please note, when we talk about why should Uniform Civil Code ever come into place for emancipation of women in society. See, the term property means security. Maintenance is liquid cash. Property is a sense of security. Property is a sense of belongingness. Belongingness to that place, to that land, to your ancestors and to your culture. And if women are denied those rights, I think every society must condemn, and I think that is one major reason why Uniform Civil Code is totally justified.
There's a question from Anushka Shetty of 5th Bay LLB. Instead of Uniform Civil Code, is it not suggestible to remove discriminatory laws instead of removing the personal laws?
It's a good point. There are two ways of achieving Uniform Civil Code, and that is already something that has been written quite a bit. One is called the brick by brick method. Professor Sunny was right in bringing the brick by brick method of Uniform Civil Code. How did we do it? We brought the Domestic Violence Act, one legislation. We brought the Elderly Citizens Maintenance Act, one legislation. You build bricks, and that is how Uniform Civil Code finally can be achieved over a period of time. Will that have the kind of timeline? Because you also need good governments to actually understand the problems in society and in personal law. The other method is to bring in the total legislation of one unified code. Why have differential legislations? Because differential legislations have actually resulted in problems. For example, under Domestic Violence Act, there is a separate authority that needs to be established. Under elderly citizens, so administrative challenges arises in the brick by brick method. A uniform code would probably be the end of all solution, but it's not the solution that is nearby right now.
So there's one more question from Sushavya of 5th B LLB. Does this code provide equal treatment for transgender?
It should.
Then there's one more thing. It's a question from general public only. So what you would suggest for implementation of universal code?
No, I have already given that suggestion, but to be honest, as a country that now is probably the third largest economy of the world, our progress is not by economic terms. Our progress should not be by, counting how many people have come out of poverty. Yes, these are also important. I'm not denying those facts. Our progress is not by the luxury and material wealth that we have. Our progress should be in our thought process. If we can change the thought process of a nation and make it more acceptable in terms of gender equality or in terms of gender sensitization, I think that could be the progress of a nation.
There's one more question from Prajvita S. from final year student. Given the fact that marriage is considered a sacrament in one religion and contract in another religion, adopting what kind would it make uniform in nature?
No, you can't choose between those that have already been prescribed by the religions. The religions are quite extreme in what they have said. If I say marriage is a sacrament in Hindu law, what is divorce? You have not defined it. You should have defined both. ಸೊ ಹಿಂದೂ ಲಾಲಿ ಅದನ್ನು ಸಾಕಷ್ಟು ಡಿಫೈನ್ ಮಾಡಿಲ್ಲ. ಹೌದು, ಸೇಕ್ರಿಮೆಂಟ್ ಯಾವುದಕ್ಕೆ ಅಂದರೆ ಅದು ವಿಟ್ನೆಸ್ಸಿಗೆ, ಇನ್ ಟರ್ಮ್ಸ್ ಆಫ್ ವಿಟ್ನೆಸ್ಸಿಂಗ್ ಬಿಫೋರ್ ದ ಫೈರ್. ನಾನು ಆ ಸೆರೆಮನಿ ಏನು ಮಾಡ್ತೇನಲ್ಲ ಅದು ನಾನು ಅದನ್ನು ಇಟ್ಕೋಬೇಕಾಗತ್ತೆ. ಹೌದು, ಓವರ್ ಅ ಪೀರಿಯಡ್ ಆಫ್ ಟೈಮ್ ಐ ಥಿಂಕ್ ವಿ ಹ್ಯಾವ್ ಡಿಫೈನ್ಡ್ ಇಟ್ ಇನ್ ಡಿಫ್ರೆಂಟ್ ವೇಸ್. ಬಟ್ ದ ಪಾಯಿಂಟ್ ಈಸ್ ದಿಸ್: Today, when you look at the rate of divorce, when you look at the rate of property disputes that come after divorce, if you look at how we are treating children, legitimate and illegitimate, the kind of issues that we are facing in society, I think the legal system demands a uniform civil code. The judicial system will benefit from a uniform civil code. I think every person in society would actually find this code to be far more useful. So I think it's a felt need from the current generation.
Thank you, sir. I kindly request Dr. K.R. Aithal, sir, to address on the question to the audience. The question is from Shashi Kumar from Ujire. If the Supreme Court has observed for uniform civil code, why the Parliament has failed to come out with a uniform civil code?
In fact, Supreme Court cannot direct the Parliament to make a law. That is what has happened recently also. The Supreme Court said you go to Parliament. That is why I said Parliament can do easily if there is a consensus on the issue. And that consensus could have been easily achieved at the time of independence. We wasted 75 years and we have to build up again the consensus. Why court should not make law? In fact, there is a provision in the French Civil Code that the court should not lay down general rules. For example, I will give you a simple example why court should not make general law. Suppose in a divorce case in Hindu law, so if all marriages should be performed, Saptapadi should be performed. If a marriage performed without Saptapadi is void, some people will be happy. But how many marriages we have to declare invalid? Because there are so many other types of marriages. Vakikal marriage among Vakaligas and Lingais, there is another ceremony. So that is why the Uniform Civil Code, we cannot define what ceremony marriage should. That is the reason why the Supreme Court said you go to Parliament, and that is why in all Hindu law, to accommodate this diversity, in majority of the provisions there is a provision unless there is a well-established custom to the contrary. That is why, in law of succession, all the three means of succession are valid. We have three methods, is it not? Matrilineal succession among Marmukata Laya, patrilineal succession and primogeniture. That is why that exception. See, even if you draft a civil code, we have to make so many provisions for exceptions. That is the problem. That is why it has been postponed.
Okay, there is one more question from Jayashri of 3rd LLB. How can a uniform civil code address the issue related to interfaith marriages?
See, marriage must be treated as a civil relationship, a relationship between man and a woman. And it should not be colored by religious rituals, practices, norms, etc. That is the problem. See, because over a period of time I had told you that civil relations are governed by religion, because that relationship can be maintained if there is some fear of divine retribution if the relationship is broken at the instance of one of the parties. To cement the relationship, because people fear God. So if you broke the religion, marriage, so that you are committing a sin. That is why, that is the reason why, that in marriages, sacramental aspects, ceremonial aspects are infused. So that people should not, in the name of modernity or whatever, so that frequently divorce should not be claimed, because that in case of fight between men and women, the sufferers are children. That is the reason why, that to make the relationship permanent. So many rules, regulations in fact have been imposed on both men and women. The problem is that, so the rules imposed upon men are less harsher than women, that triple talaq, for example. So those things should be removed, that's all.
There's a last question from Gayatri of 4th B LLB. India is a nation of unity in diversity, but by implementing uniform civil code, whether it is opposed to the cultural diversity?
See, the unity in India can be maintained if all social relationships are based on citizenship and patriotism. So today nations are not built on religion, but on political relationship built on patriotism and citizenship. So uniform civil code it is an assumption, will help us in building patriotism, and of course in our law only many things are not done in the name of citizens. All Indian citizens should be treated equally. But our own Vice Chancellor was there. Whenever we want to write candidates, he will say, you have to write within brackets SC, ST, OBC, and general merit, etc. So the society, only one citizenship should be there. That is why, to reinforce this, this uniform civil code may help. That's all.
Thank you, sir. I kindly request Dr. K.C. Sunny to address on the questions to the audience. So the question is from Rakshita K of 5th B LLB. Would uniform civil code infringes individual rights to freedom of religion?
No, I think that answer is sufficient. Okay.
Then there is one more question from Abhijit P of 5th B LLB. Whether the caste reservation will be abolished after the enactment of uniform civil code?
No, caste is one thing. Religion is one thing, then culture is another thing, language is another thing. I will take 1 minute because of
yes, sir.
When I was the director of international affairs of Kerala University, then Arabic department was started. Then general feeling that it is for pleasing Muslims. Arabic is a culture. That is prior to Islam, Prophet. Then, if we go through Palestine Christians use the term Allah for mentioning God. So, civilization is one thing, religion is another thing, caste is also another thing. So, I think that question is not at all relevant.
So, there is one more question from Shweta of 1st LLB. What changes can be observed after implementation of Uniform Civil Code?
That may depend on the content. My only point is that if we include any valid provision existing in law, that is against the Constitution or fundamental right. But in addition to that, modern ideas may also be incorporated. Because justice is a variable factor. Then our concept may change. That is why I mentioned matrimonial property may also be included. Obligation to elderly or aged parents may also be included. Obligation to family members may also be included. Then there are so many new issues like inter-country adoptions, surrogacy. All these things may be included in addition to that. Then only we can say that whether it is violative of Constitution or not. That is why I mentioned that first draft may be published. This is civil code. Then discussion, then finalize.
Thank you, sir. So if the audience has any suggestion, you can say to the panel. If there is any suggestion. Yes.
The mic to her, please.
My suggestion towards the Uniform Civil Code would be, rather than implementing and debating on the subject in certain occasions, why not go for a trial period? Like the saying goes, you don't know if it's good for you or if you like it unless you taste it. So give a trial period. For example, give it 10 years, maybe 5 years minimum, 2 years for accepting the fact that something like this is happening, 2 years for checking if it's good for you, and 1 year for deciding whether it's good for you or not, and then after the 5 years take a survey again and then decide if it's implementable or not. Yeah, so your opinion on that?
You want time frame? I think that may be implemented within 2 years and maximum 5 years. Because first draft may be discussed, then stakeholders, then that may be placed in the parliament, there may be select committee. But Parliament can enact, pass. We have passed, Rajya Sabha passed a bill giving reservation to women in Parliament. What happened? So passing a bill is not at all important. Within this framework, law may be implemented, passed by the Parliament and notified in the official gazette, signed by the President of India and notified in the Gazette. That is very important.
No, sir, why not pass it? Inform the citizens that it is a trial period. It is a trial period. Only if it's fully acceptable will it be implemented throughout the whole country and accepted by the people for the long term. But like for a time period.
There is one theory that is by Lawrence Friedman. Law cannot be imposed on a hostile community. That is true. But enactment of law itself is a catalytic fact for social reform. We have the classic example of Suddi abolition.
If there is any other suggestion, you can give it. Audience, yes.
My name is Ishwaramangala. I am the law faculty of this college. So my question is to Dr. Sairam Bhatt sir. Sir, you have mentioned about the choice-based system. So whenever we are giving a choice, obviously what is favorable to us, we will choose that choice, right? Yes. So still there are certain discriminatory provisions which are existing in the personal laws, whether it is Hindu law, Muslim law, Christian law. Discriminatory provisions are there. So by giving a choice-based system, how can we eliminate these discriminatory provisions? And apart from that, whenever we have abolished untouchability, we didn't ask with anyone. We have simply abolished the untouchability. Recently, the Law Commission, they have asked for the suggestions from the various religious organizations, saying that if you have any opinion, you can express your opinion. So we are giving an opportunity to express their opinion, and we are asking them, shall we do this? So is it really necessary in a legal system, especially with respect to this particular topic? That's my question.
See, while your opinion is important and very valuable, we have to explore so many other solutions to achieve the purpose of a uniform civil code, which you rightly said is to take away discriminatory practices in religious and personal laws. I think every step is important, right? So I think any form of discrimination is breaching the principles of the Constitution, and I think we must take equal measures to take away those discriminatory practices. The question is, like Professor Sunny said, how do you do it? When do you do it? What is the vehicle in which you do it, right? So I think we should definitely try and act more in identifying those discriminatory practices. But the problem has always been that many of these discriminatory practices have been taken by the Supreme Court. They have not been even discussed. For example, adultery as a provision or any other provision you want to take recently, the courts are actually trying to do the business what the legislature and the executive ought to have done. I don't think that is a great trend of eliminating discriminatory practices. I think as a democracy, we the people have to debate, we the people have to have a consensus, we have to acknowledge that this is a discriminatory practice, and not just because the Supreme Court has said the same. Otherwise, we are just calling upon the court to wade away those discriminatory practices. So one way, like Professor Sunny said, domestic violence and elderly citizens. But there are so many such uniform discriminatory laws that have been removed by the Supreme Court from time to time, and all women and all sections of the community have benefited from it. So the question is the choice that you make. Are you just waiting for the judiciary to come and rescue you, or will you take steps to providing those solutions as well?
So if there is any other suggestion, you can. This is the last one.
Yeah, my name is Bharat Bhai. I just have one question. Whether the faith practiced by the judges will affect the verdict, because if you see Sharia Banu case or Ayodhya verdict, the minorities were against it. If suppose it was the other way, all the all judges were practicing one community, whether there would have been difference in the final verdict is my question.
May not be. Classic example is one observation by Justice M.H. Bhatt in an election case. not I think, in election case or constitutional case, regarding the role of the religion. He said that the content of my piece presentation is also based on earlier society or in primitive society, religion interfered with all aspects of human life. Now, the role of the religion is confined to the relation between human being and God or something related to eternal birth. That is why one Muslim judge, M.H. Beck, who was the Chief Justice of India. So we cannot search about the caste of the judge, etc., etc. Unfortunately, that is happening here. That is happening here.
Thank you, panel, and thank you, audience. So now we have come to an end of the interactive session. Now I would request Dr. B.K. Ravindra sir, the moderator of today's technical session, to give a concluding remarks.
Good afternoon, friends. I will not take much of your time, only 2 minutes. I know that you are hungry, and hungry man is an angry man. If I want to confront with you, but it is my duty as a director of this law college. I am really blessed by God to get these persons, number one, including the institution also. Someone told me in the meeting, though it is kept as confidential, when my own friends are there, there is no hesitation. Friends includes you, my students also. Someone said to me, sir, you say that nearly more than 100 questions have been sent to you. You please send it to the scholars or the resource persons. Let them prepare and come. I just laughed and said, this is a height of immaturity, I said, in the governing council meeting. It is not a child play. A scholar has to prove his scholarship, and we should get as much knowledge as possible from him. Then they were not able to answer this. Why I say this is, you see here, they have come well prepared, and they were able to answer all questions. See the beauty of the senior-most lawyer, Sri Rammohan Rao. See, the thirst for knowledge or the hunger for knowledge should be there in us as law students. Till we die, that hunger should be there. We should not stop learning. It's a continuous process. Maybe you may be a doctor, or you may be a lawyer, or you may be a teacher. We should continue our learning. We should not stop. That is why they have carved out an identity in them. That's why I was just listening to him. Whatever he spoke is there with me. I was just observing my students also. My friends, where do you get this knowledge? In textbooks? Go to your textbooks. I think you will not, I and Professor Aital, we have studied the French law and as well as the UK law and US law because it was compulsory for us in master degree. But where is the chance for you? Just by listening, you can get a lot amount of knowledge which helps you in your profession, number one. Because some of the aspects when you spoke even I was not aware of. Therefore, I had to make a small research regarding that. Because that enhances my knowledge. We should have the patience to listen and exploit the resource person as much as possible and try to build our knowledge. Similarly, Professor Sairam Bhatt, he is there in the National Law School as a professor. He has been promoted as a professor, joined as assistant professor. He was able to get elevations very quickly and he has come to the position of professor because of his scholarship. The amount of work he does in the department, I think no other professor does it. I know it fully well. I know fully well. Because I had been to the national school and whenever I go, I find that he will be busy with some work or the other. He will not get time. And anyhow, but the lucky part by God's grace, whenever I contact any resource person who is a scholar, they immediately say yes. That's because of God's blessings. If I would like to introduce these persons to you, by looking at them, you get a motivation saying that I should learn like this, I should become a person like of this stature. Do you think that Dr. Suddi is so easy to get you? No. He will always be, and when even over 4, he speaks only one sentence, yes or no. See, the way he presents it was simply thrilling. It was not time consuming, but I was eager to know more and more from Tani. That is how, see, these are real scholars, my friends. Very rare we get. Therefore, we have to make use of this opportunity. Similarly, Professor Aital, he is a mini encyclopedia. You give him any subject, he will speak on that. And he will speak, he will lecture by giving simple examples. ನಮ್ಮ ಸುತ್ತಮುತ್ತ ಎಕ್ಸಾಂಪಲ್ಸ್ ಉದಾಹರಣೆಗಳು ತಗೊಂಡೇ ನಿಮಗೆ ಪಾಠ ಮಾಡ್ತಾರೆ ಅವರು. ನಿಮ್ಮ ಉದಾಹರಣೆ ಕೇಳಿ ನಿಮಗೆ ಪಾಠ ಅರ್ಥ ಆಗ್ತದೆ. ಸೊ ಈವನ್ ಜೂಲಿಯಸ್ ಸ್ಟೋನ್, ದೇ ಸೆಟ್ ಎ ವೆರಿ ಟಫ್ ಬುಕ್ ಆನ್ ಜೂರಿಸ್ಪ್ರುಡೆನ್ಸ್, ಅದನ್ನು ಎಷ್ಟು ಸಿಂಪಲಾಗಿ ಪಾಠ ಮಾಡ್ತಾರೆ ಅಂದರೆ ನಿಮಗೆ ಆಶ್ಚರ್ಯ ಆಗ್ತದೆ, ಈ ಪುಸ್ತಕ ಹಂಗೆ ಇದೆಯಾ ಅಂತ. ಬಟ್ ಅದರಷ್ಟು ಸಿಂಪ್ಲಿಫೈ ಮಾಡಿ ಹೇಳ್ತಾರೆ. ದೀಸ್ ಆರ್ ಆಲ್ ದ ಪರ್ಸನ್ಸ್. ಸಿ, ಐ ವಾಸ್ ಜಸ್ಟ್ ಅಬ್ಸರ್ವಿಂಗ್ ಎವ್ರಿ ಒನ್ ಪ್ರೆಸೆಂಟೆಡ್ made their submissions without referring to a single piece of paper. And they were able to answer questions. Even they are ready to answer more questions. But time constraint is there. We have fixed a time. Dr. Sairam has to go to Bangalore immediately now. Similarly, Dr. Suddi has to go back to Kerala immediately. Therefore, by looking to all these things, because our time constraint, well, I am happy, total happy. Though I don't feel hungry, but still hungerness is there. My mental hungerness is there. I would like to get more knowledge, because when we have such a wonderful person, Ramohan Rao, putting you so nicely, covering all aspects, what more you want, my friends? Here you learn a lot rather than in the class. In the class we go only according to the syllabus, that's all. ಅದು ಪುಸ್ತಕದ ಬದನೆಕಾಯಿ ಮಾತ್ರ ಹೇಳ್ತೀವಿ. ಇಲ್ಲಿ ಹಾಗಲ್ಲ, ಎಷ್ಟು ಯಾವ್ಯಾವ ರೀತಿಯಲ್ಲಿ ತಗೊಬಂದು ಮುಂದೆ ಪ್ರೆಸೆಂಟ್ ಮಾಡಿದ್ರು. ಈ ಅವಕಾಶ ನಿಮ್ಗೆ ಎಲ್ಲಿ ಸಿಗ್ತದೆ? ಅದಕ್ಕೋಸ್ಕರ ನಿಮ್ಮ ಒಳ್ಳೆಯದಕ್ಕೆ, ನಿಮ್ಮ ಬೆಳವಣಿಗೆಗೆ, ಹಾಗೂ ನಾವು ಬೀಯಿಂಗ್ ಸ್ಟೂಡೆಂಟ್ಸ್ ಆಫ್ ಎ law college, being teachers of a law college, let us put our reaction before the Law Commission of India. ಬೇರೆಯವ್ರು ಮಾಡಲಿಲ್ಲ ಅಂತ ನಾವು ಕೂತ್ಕೊಳ್ಬಾರ್ದು, ನಾವು ಮಾಡಲೇಬೇಕು. ಇಟ್ಸ್ ದ ಡ್ಯೂಟಿ ಆಫ್ ದ ಲಾ ಸ್ಟೂಡೆಂಟ್ಸ್. That other law colleges affiliated to the Karnataka state law need not do. I am not bothered. Either the university, if it doesn't, I am not bothered. But my college should do it. And we should be there in the first row. That's why, with a very good intention, we have done this to benefit you. See that you go with this hunger to acquire more and more knowledge, and see that instead of I arranging, you people should arrange it. You should do it. Therefore, we are on any area of law. It need not be law. It can be literature. It can be medicine. We are ready to hear. Because where do we get? Because the knowledge of medicine or engineering or literature is very important. Justice Krishna Dikshit has given a wonderful talk. How literature is important for law. It has been sent to my WhatsApp. I was really thrilled. How beautifully he has spoken. My friends, every subject is important, but law is an area where it will never end. You go on reading, go on learning, you get more and more knowledge. So I thank the resource persons wholeheartedly for their cooperation, for coming over here and delivering a talk, and our students are really pleased. Therefore, my simple request to all my students is, give a big applause to these resource persons. Thank you.
Thank you, for your concise closing remarks. We have come to an end of the program. May I invite Sri Lakshmikant Sub, Assistant Professor of Political Science, to render the vote of thanks.
ಯೂನಿಫಾರ್ಮ್ ಸಿವಿಲ್ ಕೋಡ್ ಬಗ್ಗೆ ಒಂದು ರಾಷ್ಟ್ರೀಯ ಸೆಮಿನಾರನ್ನು ಅತ್ಯಂತ ಅರ್ಥಪೂರ್ಣವಾಗಿ ಮುಗಿಸಿದ್ದೇವೆ ಅನ್ನುವ ಒಂದು ನೆಲೆಯಲ್ಲಿ ಈ ಒಂದು ಸೆಷನ್ಸನ್ನು ವಂದನಾರ್ಪಣೆಯ ಮೂಲಕ ನಾವಿವತ್ತು ಮುಗಿಸ್ತಾ ಇದ್ದೇವೆ. ಈ ಕಾರ್ಯಕ್ರಮದ ಈ ಗೋಷ್ಠಿಯ ಮಾಡರೇಟರ್ ಆಗಿ ಈ ಕಾರ್ಯಕ್ರಮವನ್ನು ನಡೆಸಿಕೊಟ್ಟಂತಹ ನಮ್ಮ ಕಾಲೇಜಿನ ಕಾನೂನು ಅಧ್ಯಯನ ವಿಭಾಗದ ನಿರ್ದೇಶಕರಾಗಿರುವಂತಹ ಡಾಕ್ಟರ್ ಬಿ ಕೆ ರವೀಂದ್ರ ಸರ್ ಇವರಿಗೆ ನಿಮ್ಮೆಲ್ಲರ ಪರವಾಗಿ ತುಂಬು ಹೃದಯದ ಧನ್ಯವಾದಗಳನ್ನು ಹೇಳ್ತಾ ಇದ್ದೇನೆ. ಈ ವಿಚಾರಗೋಷ್ಠಿಯಲ್ಲಿ ಯೂನಿಫಾರ್ಮ್ ಸಿವಿಲ್ ಕೋಡ್ ಅಂತ ಹೇಳುವಂಥ ವಿಚಾರದ ಬಗ್ಗೆ ವಿಶೇಷ ಗೋಷ್ಠಿಯನ್ನು ನಡೆಸಿಕೊಟ್ಟಂಥ ಶ್ರೀ ರಾಮ್ ಮೋಹನ್ ರಾವ್ ಸರ್ ಇವರಿಗೂ ಧನ್ಯವಾದಗಳನ್ನು ಅರ್ಪಿಸ್ತಾ ಇದ್ದೇನೆ. ಅದೇ ರೀತಿ ನೀಡ್ ಫಾರ್ ಯೂನಿಫಾರ್ಮ್ ಸಿವಿಲ್ ಕೋಡ್ ಇನ್ ಇಂಡಿಯಾ ಅನ್ನೋ ವಿಚಾರದ ಕುರಿತು ವಿಷಯ ಮಂಡಿಸಿದಂತಹ ಡಾಕ್ಟರ್ ಸಾಯಿರಾಮ್ ಭಟ್ ಸರ್ ಇವರಿಗೂ ತುಂಬು ಹೃದಯದ ಧನ್ಯವಾದಗಳನ್ನು ಅರ್ಪಿಸ್ತಾ ಇದ್ದೇನೆ. ಅದೇ ರೀತಿ ಜುಡಿಷಿಯಲ್ ಡಿಸಿಷನ್ಸ್ ಆ್ಯಂಡ್ ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ಆಫ್ ದಿ ಕೋರ್ಟ್ಸ್ ಅಂತ ಹೇಳುವ ವಿಚಾರದಲ್ಲಿ ವಿಷಯವನ್ನು ಮಂಡಿಸಿದಂತಹ ಡಾಕ್ಟರ್ ಕೆ ಆರ್ ಐತಾಲ್ ಸರ್ ಇವರಿಗೂ ಎಲ್ಲರ ಪರವಾಗಿ ವಂದನೆಗಳನ್ನು ಅರ್ಪಿಸ್ತಾ ಇದ್ದೇನೆ. ಅದೇ ರೀತಿ ರಿಲಿಜಿಯಸ್ ರೈಟ್ಸ್ ಆ್ಯಂಡ್ ಫ್ರೀಡಮ್ಸ್ ಆ್ಯಂಡ್ ಯೂನಿಫಾರ್ಮ್ ಸಿವಿಲ್ ಕೋಡ್ ಅನ್ನುವ ವಿಚಾರದ ಕುರಿತು ವಿಷಯವನ್ನು ಮಂಡಿಸಿದಂತಹ ಡಾಕ್ಟರ್ ಕೆ ಸಿ ಸಣ್ಣಿ ಇವರಿಗೂ ಸಹ ಪ್ರೀತಿಪೂರ್ವಕ ಧನ್ಯವಾದಗಳನ್ನು ಅರ್ಪಿಸ್ತಾ ಇದ್ದೇನೆ. ಇದಲ್ಲದೆ ಈ ಕಾರ್ಯಕ್ರಮವನ್ನು ನಡೆಸಿಕೊಡಲು ಅವಕಾಶವನ್ನು ಮಾಡಿಕೊಟ್ಟಂತಹ ನಮ್ಮ ಮ್ಯಾನೇಜ್ಮೆಂಟಿನ ಎಲ್ಲ ಸದಸ್ಯರಿಗೂ, ಅದೇ ರೀತಿ ನಮ್ಮ ಕಾಲೇಜಿನ ಪ್ರಾಂಶುಪಾಲರಿಗೂ, ಅದೇ ರೀತಿ ಈ ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ಉಪಸ್ಥಿತರಿರುವಂತಹ VVSನ ಎಲ್ಲ ಆಡಳಿತ ಮಂಡಳಿಯ ವಿವಿಧ ಹುದ್ದೆಗಳನ್ನು ಅಲಂಕರಿಸಿದಂತಹ ಬಂಧುಗಳಿಗೂ, ಅದೇ ರೀತಿ ಈ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ಆಗಮಿಸಿ ನಮ್ಮ ಕರೆಗೆ ಓಗೊಟ್ಟು ಬಂದು ಇಷ್ಟು ಸಮಯಗಳ ಕಾಲ ತಮ್ಮ ಅಮೂಲ್ಯ ಸಮಯವನ್ನು ನಮಗೆ ನೀಡಿದಂತಹ ಎಲ್ಲ ಪುತ್ತೂರಿನ ಬಂಧು ಮಿತ್ರರಿಗೂ, ಅದೇ ರೀತಿ ವಿವಿಧ ಕಾಲೇಜುಗಳಿಂದ ಬಂದಿರುವಂತಹ ಎಲ್ಲ ಬೋಧಕ ವೃಂದದವರಿಗೂ, ಅದೇ ರೀತಿ ವಿದ್ಯಾರ್ಥಿ ಬಂಧುಗಳಿಗೂ, ಇದಲ್ಲದೆ ನಮ್ಮ ಈ ಕಾಲೇಜಿನ ಎಲ್ಲ ಆಡಳಿತ ಮಂಡಳಿಯ ಸದಸ್ಯರಿಗೂ, ಜೊತೆಗೆ PTA ಸದಸ್ಯರಿಗೂ, ಅದೇ ರೀತಿ ಅಲ್ಯುಮಿನಿ ಅಸೋಸಿಯೇಷನ್ನವರಿಗೂ, ಹಾಗೂ ನಮ್ಮ ಕಾಲೇಜಿನ ಎಲ್ಲ ಬೋಧಕ ಮತ್ತು ಬೋಧಕೇತರ ಬಂಧುಗಳಿಗೂ, ಜೊತೆಗೆ ನನ್ನೆಲ್ಲ ಆತ್ಮೀಯ ವಿದ್ಯಾರ್ಥಿಗಳಿಗೂ ತುಂಬು ಹೃದಯದ ಧನ್ಯವಾದಗಳನ್ನು ಅರ್ಪಿಸ್ತಾ ಇದ್ದೇನೆ. ಇನ್ನು ಈ ಕಾರ್ಯಕ್ರಮವನ್ನು ನಮಗೆ ನಮ್ಮ ಸಮಾಜಕ್ಕೆ ತಲುಪಿಸುವಂತಹ ಕೆಲಸವನ್ನು ಮಾಡುವಂತಹ ವಿಕಸನ ಟಿವಿಯವರಿಗೂ ಹಾಗೆ ನಮ್ಮ ಸುದ್ದಿಯ ಬಂಧು ಮಿತ್ರರಿಗೂ, ಜೊತೆಗೆ ವಿವಿಧ ಪತ್ರಿಕೆಗಳ ಮುಖ್ಯ ವರದಿಗಾರರಿಗೂ ಎಲ್ಲರಿಗೂ ಸಹ ನಾನು ತುಂಬು ಹೃದಯದ ಧನ್ಯವಾದಗಳನ್ನು ಅರ್ಪಿಸ್ತಾ ಇದ್ದೇನೆ. ಅದೇ ರೀತಿ ಈ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ನಮಗೆ ಈ ಕಾರ್ಯಕ್ರಮವನ್ನು ನೆರವೇರಿಸಲಿಕ್ಕೆ ಸಾಥ್ ಕೊಟ್ಟವರು ರೋಟರಿ ಕ್ಲಬ್ ಪುತ್ತೂರು ಇವರನ್ನು ಸಹ ನಾನು ಈ ಸಂದರ್ಭದಲ್ಲಿ ತುಂಬ ಹೃದಯದ ಧನ್ಯವಾದಗಳನ್ನು ಇವರಿಗೆ ಅರ್ಪಿಸ್ತಾ ಇದ್ದೇನೆ. ಜೊತೆಗೆ ಈ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ಪ್ರತ್ಯಕ್ಷ ಹಾಗೂ ಪರೋಕ್ಷವಾಗಿ ಸಹಕಾರವನ್ನು ನೀಡಿದಂತಹ ಎಲ್ಲ ಬಂಧುಗಳಿಗೆ ಮತ್ತೊಮ್ಮೆ ಧನ್ಯವಾದಗಳನ್ನು ಅರ್ಪಿಸ್ತಾ ಇದ್ದೇನೆ.
Thank you, sir. Let us end the session with the Shanti Mantra. All sit in a comfortable position. Join your palms and gently close your eyes. Om Sarve Bhavantu Sukhinah Sarve Santu Niramaya Sarve Bhadrani Pashyantu मा कश्चित् दुःखभाग् भवेत्. ॐ शान्ति शान्ति शान्तिः. Thank you. Lunch is arranged in the room number 004 for guests, parents, public and faculty members. For students, for girls, lunch is arranged in the room number 005. For boys, it is arranged in the room